I've got one matter, Milord, pending for the revision hearing, Milord, and previously it was
Monday, I have taken up all the mentionings and I've already made it clear that no further mentioning will be taken for inclusion.
no, it is ma'am, Milord, it is for the extension of interim order.
When is it expiring?
It was already expired, ma'am, Milord.
File application.
No, I had
Yes,
already
already.
filed, Milord, and it is pending, Milord. And the next date is in the lower court is on 30th of this month only.
Next date is
30th of this month only.
13th,
30th.
30th.
Yes.
30th for what?
For that revision application is here, Milord.
Let it appear on that day, then you can mention. Today it is not required. Yes.
No, it is not in the list out here.
I understand it's not in the list. When it will appear on 30th, then mention.
No, that matter is pending in the lower court and date is fixed on 30th of lower court, Milord.
In the lower court, it is fixed on 30th.
Yes, Milord.
All right, give. Who is your other side? Who is your other side?
PP, let
You have to serve notice.
Subhasis.
You have to serve notice upon the other side. Did you serve the copy of the application?
No.
Do all those things. How can it be done?
Okay.
You finish all the paraphernalia and then come. Yes.
The hearing matter, Milords, I am appointed in this matter by the High Court Legal Service Authority. This matter has been pending since 2019. Last occasion, there was a direction, Milords, to finalize certain documents. So it is not appearing in this. It was mentioned yesterday as well, Milords. Kindly take this up, Milords.
Yesterday means day before yesterday on Monday. If it has been mentioned, then matter will appear. Don't mention again. No. It has already been mentioned. It is not required. Yes. No, I never directed anybody that the matter will appear today. Slips have been accepted, but all matters will appear today. It is not possible.
In that case,
No, don't give any further slip.
The other two matters, these have not been mentioned.
No, please then don't mention. More than 60 matters have been mentioned. 60. No, sorry. It's impossible. It's impossible. Yes.
Lordship, one request, my lord, regarding my lord criminal motions, my lord, criminal revision, Lordship, may I mention two matters for inclusion in the list, because my lord, these are relating to the transfer of the criminal proceeding, my lord.
Justice Sen is taking up certain matters. I see in the list of Justice Sen, CRR. Please mention over there. Yes.
On the restoration application.
No, don't mention.
Madam, I'm mentioning a criminal revision matter.
Mention before the other bench. Other bench is taking up matters. Yes.
Lordship, restoration matters. The application has already been filed, and we have mentioned this. CAN application has already been filed.
When did you mention?
Monday, Your Lordship mentioned.
Monday, if it has been mentioned, then please don't mention again.
Okay.
Yes.
Lordship.
Motion, it will come up in usual courts. Please don't mention.
Lordship.
Yes.
Lordship, may I leave to mention one matter, Lordship?
Yes.
Lordship, these and restoration application at motion stage matter was dismissed, and there was a direction upon the respondents to first submit a report, and an unauthorized construction is going on the land by the government of West Bengal, on my land, Lordship.
First, then you mention.
I have served notice. Lordship.
You have served notice. Monday, all mentionings were taken up. You wait for next week. Today, no further mentioning. Call the list.
Lordship.
Next circuit. Very well. On the prayer made by the learned advocate representing the petitioner, list the matter in the next circuit.
Milords, I am appearing for the petitioner, Milords.
Yes.
Milords, I have served the Milords affidavit. They are affirming it. They are affirming the service, affidavit of service, Milords.
Who is
Milords,
appearing? Where are the councils for
they
the
have
state?
not appeared, Milords.
What happened to the councils for the state? Are you there for the state in this matter?
Item number 2.
My lord, in this matter, I need seek instruction, my lord.
You need instructions?
Yes, my lord.
How soon can you get it?
2 days, lordship.
What is the matter about?
Milords, I'll tell you, Milords. I am a son of a person who was an East Pakistani refugee.
Yes.
My father was allotted a plot of land subsequently RS and LR was also recorded in my father's name. From 1980, my lords, I have been filing, initially, although my father was allotted the land, but patta was not physically handed over to me. From 1980, I have been filing application before different authorities, but till now, neither my mutation have been
Where is your
processed.
application?
My representation, my lords.
Yes.
My lords, page number 30 to 39 are my different representation. The last one was at page number 36, my lords.
Twenty 13.
Yes, my lords.
There
After
are,
that also, my lords, I have filed several, but
where are those?
my lords, kindly allow me leave, then I'll file a supplementary affidavit due to inadvertent error, my lords.
And page 36, where is the receipt?
It's not there, my lords. My lords, kindly take page number 40, my lords, of my petition.
Page number 38, there was a direction for appearance.
My lords, there are several directions from 1980. They have summoned me several
When
times.
can you file the supplementary?
My lords, maybe give me 2 days or 1 day. I'll file it tomorrow.
Do you have the copies?
Yes, my lords, I have the physical copies.
If you have the physical copies, you ought to have annexed it with the writ
My lords,
petition.
I know, my lords, due to inadvertent error, my lords, it was not.
Why will this permission to file supplementary affidavit be given to you?
My lords, my concern is that, my lords, my grievance has not been addressed, my lords. From the last 40
You
years,
have
I
to
have been
show
running,
before
my
the
lords.
court that you have raised a valid grievance before the authority. Where is that? I can see, in fact, you have shown me the document of 2013.
Yes, my
It
lords.
was 10 years back.
My lords, after that also I have filed several, my lords, due to inadvertent error, I could.
Please come. Learned advocate representing the petitioner submits that due to inadvertence, certain documents could not be annexed to the writ petition. Stop. Leave has been sought for filing supplementary affidavit.
The receipt.
Paragraph. It appears from the submission made on behalf of the petitioner that the documents which are alleged to have been missed out due to inadvertence are extremely vital for the purpose of effective adjudication of the instant lists. Stop. Next. In view of the above, leave is granted to the petitioner to file supplementary affidavit annexing documents in support of his claim by 29th of January 2024 and serve a copy of the supplementary to the learned advocate representing the state respondents. Stop. List on 31st January. Paragraph, learned advocate for the state shall come ready with necessary instruction in the matter.
My lords, service may be kept on record.
Affidavit of service is taken on record.
My lord, I appear for the writ petitioner, my lord, seeking leave to file the affidavit of service in course of the day, my lord. It has not been affirmed.
If your other side is here, no issue.
Lordship, I on the still.
My lord, I am led by Mr. Devashish Kundu. He's not there, but I'll proceed.
Please do.
My lord, here, what has happened is that I was the owner of a particular plot of land. My lord, measuring
Any
about,
instructions?
No, Lordship, 1 day accommodation, Lordship.
How can 1 day accommodation? What is your prayer?
Monday.
my prayer is twofold, my lord, rather threefold. First, my lord, that I may be paid compensation for the my land which has been acquired. Second is the demarcation is very important.
Has award been passed?
I am not aware of that. What has happened? I'll briefly, my lord,
When did the acquisition take place?
2014.
2014, and you
Yes.
are you still say that you have not been paid the
Yes,
award?
my lord.
Well, it's, usually the NH authorities do not do these.
No, what I'll tell you, lordship, my lord. Then lordship comes to one annexure. It will make it clear at page 60. Now,
In that case, I see page 68 a representation. Let that be considered.
my lord, and a
Well,
demarcation may be, well, what has happened is finally I was in possession of 0.33 acres of land.
No, whatever. Is your prayer for demarcation there in this
I
representation?
think so, my lord. Let me just, yes, it is there.
If it is so, then it is all right. Otherwise, then it will not be possible.
Yes, lordship.
Yes, demarcation is there,
Yes,
page
lordship,
73.
Page 73.
Please
Demarcation.
come.
Is the party in this case, we are not answering. You please record our presence of.
Yes, certainly your presence will be recorded. The instant writ petition arises out of the grievance raised by the petitioner on account of non-payment of acquisition charges and non-demarcation of the plot of land which has been acquired by the National Highway Authority. Now, which has been acquired by the state respondents for the National Highway Authority. Stop. A representation was filed by the petitioner through his legal representative. Stop. The same is yet to be considered. Stop. Next. Without entering into the merit of the prayer of the petitioner, the instant writ petition is disposed of by directing the
Respondent number 4, my lord. The competent authority under National Highways Act and Special Land
respondent number 4
who is addressee 3
to consider and dispose of the representation filed on behalf of the petitioner in accordance with law after giving a reasonable opportunity of hearing to the petitioner. Step. The petitioner shall be permitted to rely upon all documents in support of his claim at the time of hearing. Step. A reasoned order shall be passed and communicated to the petitioner within a period of 8 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward a copy of the representation dated 24th November 2023 to the aforesaid respondent at the time of communicating the order of the court. Paragraph. It is made clear that the court has not entered into the merit of the claim of the petitioner, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the representation. Disposed.
Grateful. In course of the day. Grateful, my lord.
May it please your lordship. My lord, I am appearing for the petitioner in the matter. My lord, this relates to illegal actions of the GST authorities in intercepting a vehicle. My lord, briefly, the facts are thus. On 6th of December 2023, my lord.
Please wait
This-
one. Is the respondent represented?
Your lordship, I'm for the petitioner.
The petitioner is all right. You are for which respondent?
Respondent number
5, 6.
5 and 6.
My lord, respondent numbers 5 and 6 are the private respondents. my lord.
Respondents. And they are pro forma. So the
They are
petitioner
pro forma.
will not be having any claim against you. What about the official respondents? Are you there?
PTSD is there separate council.
We are for the Union of India.
Union of India. What about the taxing authority? Who appears?
Advocate Rotman,
Where is he?
He's on the way.
He is on the way.
She intimated that. He's on the way.
Then what is to be done?
Okay, keep it in Passover.
Passover. A Passover has been sought. Petitioner
My lord, I leave it to your lordship, my lord. There's some urgency I'll be indicating, but I
Taxi,
leave it to your lordship.
in his absence, it makes,
Indeed, my lord. They are the primary respondents and our relief is basically against them, my lord. Respondent numbers 2 to 4,
I'll finish up with the motions and then take up the passover matters.
my lord.
Wait, your lordship. Next one is the same thing? Is the next one the same
No, ma'am.
thing?
But I am for the petition in this matter, my lord.
Is it a taxing matter?
No, not really, my lord. It is under the Forest Act.
Is the respondent there?
No, nothing Forest Act.
State?
My lord, in this matter, my lord, Mr. Navankupar appearing on behalf of the estate, my lord. He is
Yes.
court number 2, my lord.
What is to be done? Nobody assisting? I see two councils always appearing. Where
Yes,
are,
my lord.
where is the other one?
AGP is appearing also.
Where is he?
My lord, he is not well, my lord.
Not well.
Yes, my lord.
In that case, I'll pass it over for the time being. Let the
Well, only 1 day accommodation, my lord.
one-day accommodation. Then take down an order. An accommodation has been sought for on behalf of the learned advocate representing the state respondents. List tomorrow?
Lordship.
Very well.
Yes, 6 I beg to appear on behalf of Siliguri Municipal Corporation.
Now, represent. Yes,
Lordship, they have one.
Plan for the petitioner.
who is Mr. Dhar appearing for?
Siliguri Municipal Corporation.
All right, Siliguri Municipal Corporation.
Yes.
All right, yes.
Allegation made by the private respondent made a four-story building.
Where is
without-
the service upon the private respondent?
Yes, my lord. Must service, my lord.
Not received?
Yes, my lord. It is showing. Yes, my lord. Received.
Received?
Yes, my lord. Received.
Very well. Yes, now what is your prayer?
My prayer was they without according to sanction plan, they did not giving the proposed adjoining space, my lord. The constructed building, my lord.
Where is your objection?
My lord, my objection, my representation is there, my lord.
Where is it?
My lord, page 13 and 14, my lord.
Page 13 and 14.
Yes, my lord. 14 is the, my lord, specific last.
Yes, what is your
Yes,
submission?
Lordship. After the petition has been filed, the department conducted an inspection upon prior notice. Notice was given to the private respondents, the Bhaskar Chandra, and in their presence, the inspection was.
What does the inspection report say?
Kindly take the inspection report. Site inspection report.
আর একটা কি দিচ্ছি?
The inspection report says that as per sanction building, the ground parking is 3 storage residential building. As per the site, the skeleton structure of the ground is 3 storage building has been completed in deviation of the sanction building plan. There are deviations. And finally, a notice has also been given to the private respondents saying that to rectify the deviations. This is the final.
Please come. The petitioner complains of illegal and unauthorized construction at the behest of the respondent number 5. Stop. Objection was filed before the Siliguri Municipal Corporation. Stop. The petitioner complains that the objection was not taken up for consideration by the corporation. Stop. Learned advocate representing Siliguri Municipal Corporation submits upon inspection that on receipt of the objection from the petitioner, a date of inspection was fixed and notice of the inspection was served upon the private respondent. Stop. The inspection was conducted in the presence of the private respondent. Stop. It was found that there has been deviation at the time of raising the construction. a notice was served upon the private respondent for rectification of the deviated portion. Stop. Next paragraph. None represents the private respondent despite service. Affidavit of service filed in court is taken on record. I'd say. As it appears from the instruction forwarded by the corporation that steps have already been taken to redress the grievance of the petitioner, and it was found that unauthorized construction in the form of deviation exists at the subject premises. Accordingly, the Commissioner, Siliguri Municipal Corporation, is directed to take necessary steps to redress the grievance of the petitioner. Stop. Next. Remedial steps shall be taken in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order. The writ petition stands disposed of. Instructions forwarded by the Siliguri Municipal Corporation be retained with the records.
Well, I'm appealing for the state response.
Please record your appearance.
Lordship, I am for the petitioner. Lordship, this matter has been become infructuous, Lordship. The grievance of the petitioner has been redressed by the
Please
responding
come.
authority.
I am appealing for the corporation.
Learned advocate representing the petitioner submits upon instruction that the grievance of the petitioner has already been redressed by the respondent authorities. Stop. Next. In view of such submission, there is no requirement of proceeding with the writ petition any further. Stop. The same stands dismissed as being infructuous.
Grateful, Lordship.
Item number 8, Lordship. I am praying for adjournment context of the matter on Monday.
Who are you for?
I've been asked to appear on behalf of the petitioner.
Petitioner.
Lordship. Monday.
I am on behalf of the state, my lord.
Ready with instructions?
My lord, I am ready with my instructions.
And is there any private respondent or anybody of that sort?
I don't
Yes.
know.
Private respondent is there, my lord.
Then serve
See the inaction on the part. It is in action on the part of the police, my lord.
police. Serve
Yes, I shall. Monday.
Sharp na 8 number cholche.
on the prayer of the learned advocate representing the petitioner. List the matter on 29th January 2024.
My lord.
Great.
My lord, I am for the petitioner. My lord, in this matter, Mr. Suman Shah is appearing on behalf of the petitioner. My lord, he is seriously ill. My lord, kindly make it not today, my lord.
Only one day accommodation,
one day.
seriously ill.
My lord, that's-
Let it be placed in the next
No, my
circuit.
my lord, kindly make it 1 day accommodation.
What is the matter, Aliwar?
Represent the state in this matter.
What is
This
the matter
matter
about?
is, Regarding works contract. Works contract.
Works contract.
Yes.
When was the contract
And-
issued?
The contract was issued by the respondent number 3 and 4.
Are you representing 3 and
No.
4 also?
No.
3 and 4, Malbajar municipality, who
Yes.
appears?
There has been one more representation which has been
Who
filed.
appears for Malbajar municipality? Nobody is aware who appears for the municipality?
No one. No, no, my lord.
None represents Malbajar municipality. Stop. Learned advocate for the petitioner seeks accommodation for the day. Stop. List on 29th January 2024. Stop. Service shall be made upon the municipality. intimating the next date of hearing. Service shall be made a জায়গায় লিখুন তো notice shall be served upon the municipality.
Ten Milord, make it next circuit Milord.
Next circuit?
Yes.
Why? What has happened?
Mr. Bari is appearing, but he is not unfortunate.
Very well. On the prayer of the learned advocate representing the petitioner, list the matter in the next circuit.
I'm for the state, my lord.
Where is the petitioner? None represents the petitioner at the time of call. देखिए एक minute file टा. What is the matter about?
Well, there was a previous writ petition by the same writ petitioner where the order was passed upon the block land and land to give a hearing to the petitioner regarding his recording of his plot of land in his name. That is the recording of LR record of rights. He was given a hearing. Hearing was conducted. Reasoned order was passed. Subsequently, this writ petition was filed, stating claiming to know the names of the persons against whom the said application was made, means the opposite parties. And the names of the opposite parties are in the order sheet themselves. He can apply for the order sheet of the said proceeding, and he will get to know the names of all the 31 persons who are issued notices in the said application. For the purpose, the writ petition is absolutely unnecessary.
Where is the learned counsel Abhilash Mittal? None represents the petitioner at the time of call. List on 30th of January. You please give one intimation to him so that we can dispose it off on the next day.
Lodge.
Item 12, my lord. Item 12, my lord. I am for the petitioner, my lord. I am appealing virtually, my lord.
I am appearing on behalf of the School Service Commission.
My lord, my case is, my lord. Petitioner is this is a matter of, my lord, transfer of a school teacher on medical ground. My application is pending in the DIA. Due to suspension of the portal, it has not been processed. Only I am beseech to your lordship, let a direction be given to conduct my medical test. If I am cleared this medical test, it should be routed through the proper channel. That much I have only paid. My lord, I am covered by a division bench judgment that is in page 30. I have annexed your lordships. I am relying paragraph number 2, 3, and 4 of identical issues involved. At least my medical examination be done, and if I am qualified, that medical examination should be routed. Only this much.
But then where is the prayer? Where is your prayer for?
Yes. My lord, 29, page 29. My lord, my application has been routed to the DI, posted to the DI.
Please come.
My lord, I am appearing on behalf of the School Service Commission, my lord. My lord, I have not received yet a brief. My lord,
I shall give you.
You shall give me. And another thing, my lord, from the 2015 regulation of transfer regulation of School Service Commission got amended in the 21st of August 2021, and where it was specifically said in the said regulation, amended regulation, there's no offline application will be entertained henceforth. And thereafter, my lord, there is only entertainment in the online application which was received from the concerned transfer aspiring
division bench. My lord, I am covering division bench judgment.
My lord, the division, I do not have the copy of the writ petition. So, my lord, I
shall give you. I shall give you.
Please come. The petitioner.
I shall give you.
And another thing, my lord, the division, probably the division bench judgment which my learned friend is relying, my lord, in that case, my lord, district inspector of school recommended the case of the petitioner to the school service
No,
commission
no,
for
no,
hearing
no,
from-
no, Mr. Roy, no. It is Tanushree Ghosh, MAT 1332, identical issue, DI matter is pending to the DI. I shall give you copy, don't, today, by today.
The medical examination of the petitioner is yet to be conducted.
Yes.
The application for transfer was submitted successfully and a transfer ID number was also allotted to the petitioner. Stop paragraph. The petitioner relies upon an unreported order passed by the Honorable Division Bench of this court on 19th September 2023 in Math 1332 of 2022, Can 1 of 2022. In bracket, Tanushree Haldar versus State of West Bengal and others, page 30. Stop. Paragraph, it appears that in the said order, the
Paragraph
within bracket, secondary education was directed to consider the application of the petitioner in specified time period and time period relying upon the medical report of the petitioner. Stop. Next. The
respondent number 5 should be DX.
but tell me, the medical examination will be conducted by the DI.
No, my
CMOH,
lord,
CMOH, concerned CMOH.
My lord, the petitioner will
keep making-
forward the application to the through the head of the institution to the district inspector of school, and district inspector of school, my lord, forward the case of the petitioner to the CMH for medical examination.
The DI is to forward it to the CMOH.
CMH.
It is
Chief Medical
under the
Officer of-
supervision of the, yes, but under the supervision of the DI ought to forward it, but ought to conduct the medical examination through the COH, and if the medical examination clearly cleared by the petitioner, it should be forwarded.
Schools is directed to conduct the medical examination of the petitioner through the concerned Chief Medical Officer of Health. And if the report of the petitioner suggests that a transfer is required, then take necessary remedial steps in the matter, not
Lordship,
remedial, essential steps.
My lord, kindly may I pray for one indulgence, my lord. My lord, kindly record my submission that presently, due to suspension of the Utshasri portal by the government of West Bengal, no transfer application is entertaining by the School Service Commission is not entertaining any transfer application, madam.
But what is the use of recording your submission?
Because, my lord, then, my lord, each and every, if your lordships is considering the case of the petitioner in the present writ petition, my lord, each and every case by showing your lordship's order, my lord.
Division bench passed this order, Honorable Division bench passed this order.
For me, my lord.
Several judgment, Mr. Rai, several judgment, series of judgment.
I'm not standing away from the petitioner, my lord.
Advocate representing. Who are you representing, Mr. Roy?
School Service Commission, my lord.
Acha. Representing the West Bengal Central School Service Commission, submits upon instruction that at present the Utshasri portal of the government is kept suspended. Step paragraph. The submission of the commission has been taken care of by the Honorable Division Bench in paragraph 3 of the order referred to herein above.
Great.
Extremely grateful, extremely grateful.
The district inspector schools shall take steps in the matter at the earliest, but positively within a period of 8 weeks from the date of communication of this order.
I am extremely grateful. I am extremely grateful.
Grateful.
Pencil.
I am appealing for petition.
Malad, this matter I'm led by the learned additional advocate general Malad. Malad, I've just received the instruction Malad. Malad,
Go through it, 1 page or 2 pages instruction, how much
Lordship,
time
in
does
this
it take?
matter, what has happened, the petitioner before your lordship is a member of Kalchini Gram Panchayat.
Yes,
And lordship, there is several corruption going on in the Gram Panchayat. Work tender was given, work was never done, and the bills were paid. And lordship, in this regard, the petitioner made RTI application, and the kindly see the
did
reply.
you serve the panchayat?
Yes, lordship, all have been served.
Why did you not make the panchayat a party?
Lordship, Lordship, respondent number 5 is the Pradhan Kalchini.
It's not the pradhan, it's the panchayat itself who has to be made a party.
Then lordship, I will amend add.
And where is your representation?
There is no representation. The RTI application the petitioner gave, and in reply to the RTI application, they have.
And the data mentioned in the letter is not available with the NIC. What is the information that you seek?
Lordship,
Resolution of the general body.
paragraph 8, lordship, kindly see, provide
Provide
the
me from
resolution
multiplies. Provide me your-
from 26 and from 27.
You are not satisfied with the reply given by
Lordship,
the PIO. There is a provision for filing appeal. Why don't you prefer an appeal? Please come. The petitioner applied under the Right to Information Act, 2005, for obtaining certain information from the
Lordship, representations are there, lordship. Kindly see
Gram
page
Panchayat.
30 and 31, lordship. I have made representation.
Stop. The information provided by the senior director within bracket IT and the public information officer. কি দিয়ে শুরু করলাম? না, the information এর আগে একটু লিখুন. The petitioner is dissatisfied with the information provided by such and such. Stop. Next. The petitioner has filed the writ petition for relief.
Lordship,
Stop.
there are representation, lordship, let them be considered.
But then you want information, isn't it?
No, lordship.
Which representation do you want to be considered?
Page 32, lordship.
What will the police do? Till you obtain certain instruction, you have said that I have come to know that bills were issued. Can the police act on this?
Let the FIR be registered, let the investigation be done.
No, no. If FIR is not registered, 156 clause 3 proceeding is available to you. That way you cannot do it. Acha. The court is of the opinion that for relief. Stop. Paragraph. The court is of the opinion that if the petitioner is dissatisfied with the information provided by the public information officer, comma, the petitioner should have approached the appellate forum for relief. Stop. The writ petition at this stage will not be maintainable in view of the specific provision in the Public Information Act, 2005. Stop. Next. In view of the above, the writ petition stands disposed of. Stop. It will be open for the petitioner to approach the appellate forum for relief. Affidavit of service is taken under. Yes, next matter, please.
Well, at next matter, I appear for the petitioner online.
My lord, in this matter also, I am appearing on behalf of the Central School Service Commission. My lord, I have not
But,
received the brief from the commission yet. My
But
lord.
I tell you, my lord,
The
I
commission
will,
has received the brief, my lord, but I have only received the information that you have been allotted the brief, my lord. So, my lord, kindly take up the
my
matter
lord,
tomorrow, my lord.
it's a matter of, my lord, I will provide the brief to Mr. Roy. My lord, nothing doing. Now, if your lordship kindly takes up my writ petition once, my lord, I was appointed as a teacher, my lord, on 24th of September 2018. My lord, I have crossed 5 years of service. Now, my lord, the distance from my my lord, house to my working place is 739 kilometers. My lord, page 35. Now, my lord, the difficulty is that my lord, I made a representation at page 36 to the my lord, Commissioner of School Education. Now, the problem is that my father is suffering from various ailments, and my lord, since 2018 onwards, my lord, he is under constant treatment from the medical practitioners. My lord, all the prescriptions and the certificates I have annexed. Now, my lord, I made a representation to the commissioner, my lord, which has not been disposed of till date. Now, your lordship kindly takes up that my junior is there, Mr. Navankar Pal. But similar issue was considered by the division bench, but on 24th of August 2023 in the matter of Shubhadeep Ghorai. Now, the court has said that if in that matter also, the 5 years embargo was there because the petitioner could not fulfill the 5 years service. Here, I have completed 5 years. So, the court directed if Mr. Pal hands over the order copy to your lordship, the court directed that the Commissioner of School Education will consider the representation which has been filed by that petitioner before the commissioner. But the case which has been made out before the appellate court and considered by the appellate court is that the special rule which says that the importance of the application for transfer is to be determined first. Here, I have annexed all the documents of my father, and because of the distance, I am an unmarried fellow. Because of the distance, I cannot travel to Paschim Medinipur from Kuch Bihar. A similar order was also passed on 1st of November 2023 by this honorable court, by Justice Abhijit Gangobadhyay. The similar issue, the distance was the issue. Below 5 years, the court directed the commissioner to consider and pass the order. If I request Mr. Palmer to hand over both the copies to your lordship.
The petitioner seeks general transfer. Stop. His application is pending consideration at the end of the Commissioner of School Education.
My lord, not the application, my lord. My lord, it is the representation the petitioner made before the Commissioner of School Education. Ultimate
is pending consideration. But then, Mr. Bhattacharya, aren't you supposed to submit this application online?
No, because of the embargo, I cannot do it online. It has to be done offline. Kindly takes up page 37, all the postal receipts are there.
But in any case, my lord, the application has to be first forwarded to the head of the institution. Then you will come to the district inspector.
No. I can definitely serve it to the commissioner.
My lord, another thing, my lord, which is required to be considered first, my lord, that on the petitioner is submitting that his father is suffering for various ailments. For that, my lord, petitioner wants to transfer from the Kuch Bihar to Paschim Medinipur.
Ground.
There are two grounds. Distance as well as the medical ground of the father. The medical ground of the father is not at all maintainable because the rule does not provide. Rule is only providing only the medical application will be entertained where the spouse as well as the son or daughter is suffering from the various ailments as stipulated in the rules. Another thing, my lord, from 29th of December 2023, my lord, Utsav Postal has been suspended. So therefore, presently there is no provision of entertaining of the application any offline or online. And offline regarding entertainment offline application 2015 rules which permits the petitioner to made offline application had got amended in the year 2021 8 August 21st August. So my lord, in rule 4 of this 21st of August 2021 amended rules specifically provides that the applicant only the applicant only may apply in online only. There is no, my lord, provision for entertaining of the offline application from the any of the transfer aspiring candidates, my lord. These 3 points should be considered, my lord.
Advocate for the petitioner submits that the representation had to be submitted offline. The portal for submitting online application has been suspended by the government. Paragraph. Learned advocate representing the commission submits upon instruction that there is no merit in the representation filed by the petitioner seeking transfer. Paragraph. Without entering into the merit of the claim of the petitioner seeking transfer, comma, as it appears that the representation filed by the petitioner is pending consideration at the end of the Commissioner of School Education, comma, accordingly, comma, the instant writ petition is disposed of by directing the Commissioner of School Education to take a decision on the representation filed by the petitioner in accordance with law at the earliest, but positively within a period of 4 weeks from the date of communication of this order.
Grateful.
The writ petition stands disposed of. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the representation seeking transfer dated 12th December 2023 to the aforesaid respondent at the time of communicating the order of the court. Writ petition disposed.
Grateful.
State, please record your appearance.
Yes, ma'am. Thank you. Yes, Chitrat.
I appear for the petitioner.
Yes.
Mr. Pal is there to assist your lordship with the affidavit of service.
What is your prayer?
Your lordship kindly turns to page 89, your lordship's own order.
Where are the respondents?
Where are the?
State respondents. Who is appearing?
That copy has been served. If your lordship kindly takes up page 89.
Development Agency.
But Mr. Pal is there to assist your lordship. Similar matter,
Please
same
check.
appointment.
It has been served or not?
State has been served on 17 January.
Nobody there for the state? Please check up.
Maybe they are engaged in court number 2, my lord.
Maybe will not do. Tell me if somebody has been engaged or not. What is your prayer?
The same prayer, same order, I'm praying for page 89 to 92. Your lordship's own order. Takes the my lord's order.
OSD Special Secretary, Department of Panchayat Rural Development, West Bengal State Rural Development Agency.
Here is page 20.
Why have you filed another writ petition, Mr. Bhattacharya?
The petitioners have been prevented from entering into the employment center, into the panchayats. The Pradhan says, as you don't have any order in your name, I will not allow you to work. That is why we have come to your lordship.
The Pradhan is saying so.
Yes. Because all of the petitioners, they are working in the panchayat. But no circulation from the government side. That is the problem. This order should have been circulated. But the persons who got the fruit of the order, they have been prevented.
Affidavit of service filed in court is taken on record. There is no representation on behalf of the respondents.
My lord, Caesar to come back with some instructions. I'm
Yes.
engaged in this matter.
Yes.
My lord, I'll take some
I
instructions.
understand.
Come back.
List on 30th January 2024. Stop. Let notice be served upon the respondents intimating the next date of hearing. In case you are appearing, then please come instructions.
Not appearing.
Learned advocate for this respondents shall come ready with necessary instruction in the matter. There is already an order.
Yes, ma'am.
I do not see the requirement of filing the petition.
The further notice is to be served.
Is to
The 30th.
30th.
To all the respondents or to the learned advocate who is appearing for the respondents?
I don't know if you can get hold of somebody, then it is all right. Because nobody is appearing, I see.
Well, my learned friend is appearing, my lord, for the respondents. He said just now.
No, he isn't. Had he been have
The
directed
state has been served. State.
Check up who is the learned counsel. Give a notice.
Grateful. 30th.
Is 16 the same thing?
No, Malad. Different.
It's different. Anybody there for the respondent?
I am for the petitioner, Malad.
Union. What is the matter?
If you also kindly comes to page 74, this is the order passed by your lordship on the in the first writ petition, Malad. Page 74.
Yes.
Malad, person to that, Malad, if you also kindly comes to page 80, Malad. 79, Malad. Malad, this is the order they have passed rejecting my application, Malad. Now it on a different ground. Earlier it was age, now on a different ground. So thereafter I made an application seeking information under the RTI Act, Malad. The first application is at page 85. Thereafter, an appeal has been preferred. Second appeal has been.
1 minute, 1 minute. Yes. Page 80, you say.
It's 79, my lord.
Yes. And whereas in view of the court's order in severe circumstance stands implemented with due consideration of your case, as per direction of the Honorable Court, no compulsion will be made against a future vacancy. No waiting list, and therefore you are free to apply for the next extended year of vacancy. If there is no change of your financial economic condition, this brought after 80, what happened?
Now then I sought for information under the RTI Act, my lord.
Yes.
Page 85, my lord. This is my application.
Then
thereafter, my lord, first appeal, page 88.
What do you want now?
Well, I'm seeking the information. They have not yet. I'm preferred the second appeal also. They have not.
What exactly is the information that you seek?
Well, photocopy of the DOPT and DOP and T guidelines as per which the compassionate appointment is considered. Photocopies of all 100-point scale placed for assessment before the board of officers.
100-point scale?
Yes.
What will you do with the scale?
Malad, as per the latest, Malad, latest dated such and such.
Page 79, point number 4 units.
Therefore, photocopies of assessed 44 relative merit points. Photocopy of the letter bearing number such and such. All these, they have failed to provide. Not they have. Lastly, they once they have communicated that the second appeal is out of time. So you should have preferred. You should also made an application for condoning the delay. That has also been filed, submitted. Thereafter, no reply.
Condonation of delay application has been filed.
Yes.
Grounds for condoning the delay.
If you also kindly comes to page 98.
Tell me one thing. When did the employee die?
2016.
2016,
my lord.
And when was the application made?
My lord, application was made. No, don't take. In the year 2016 only, my lord. DD form was supplied
No, no, no.
on in the year.
27
Yes, my lord.
2008.
No.
18.
No, no.
22, I see.
No, my lord. I shall show, my lord.
Lordship, it is 22nd June 2018 is the application of the petitioner for compassionate appointment. ও বলাটা শেষ করি মাঝখানে ঢুকে দিয়ে
My lord, kindly sees page 25, 11th August 2016. I have submitted a DD form.
Your case was placed with the Board of Assessment of Relative Merit Point and for the recommendation of voting.
It was forwarded to me to submit the DD form, my lord. Kindly sees, prior to that I made application. Is there communication, my lord?
Do you have the copy of this DOPT and the relative merit point? How is it assessed? Please come. The prayer of the petitioner seeking compassionate appointment
Lordship, may I be permitted?
stood rejected by the order of the commandant on 31st March 2022. Stop. The petitioner filed application under the Right to Information Act seeking certain documents with relation to the rejection of her prayer. Stop. Next. The same has not been supplied. Stop. The appeal preferred by the petitioner under the Right to Information Act stood rejected on the ground of delay. Stop. The petitioner has filed an application seeking condonation of delay in filing the appeal before the appellate authority. Stop. Paragraph. The respondent authorities are directed to file a report by way of affidavit disclosing the DOPT guidelines, comma, the relative merit point assessment relying upon which the prayer of the petitioner seeking compassionate appointment stood rejected.
And on a point 9, my lord.
Point?
9.
Where
86.
Page 86. Name of all the applicants who applied, including their date of birth, along with the proof of the date of birth. If you get the relative merit points, this assessment possibly will contain
Yes, ma'am.
the details of all the candidates.
Yes, ma'am.
Isn't it? Then what is the use of separately getting serial number 9?
Lordship.
Yes, please.
Maybe please enough to keep the point of jurisdiction open because my humble understanding of this writ petition, none of the respondents reside within the territorial jurisdiction of this honorable court.
Where do they reside?
Out. Pune, Delhi.
No, assuming they stay outside, but since it's all India service, why cannot the writ petition be maintainable here? Because
The petitioner has to demonstrate that any part of cause of action arose within the jurisdiction of this honorable court.
yes,
This is the second round of writ petition. Therefore,
1 minute. Where was her husband working?
Pune.
Husband was
Husband
staying
expired at Tufanganj, my lord.
2000
Expired at Tufanganj.
Tufanganj.
Yes.
Very well.
My lord, death information, it is at page supplied to, my lord, if you kindly comes to page 20. The death certificate, page 19.
আচ্ছা একটু লিখে দিন তো কোনটা না 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 ফ্রেশ একটা প্যারাগ্রাফ শুরু করুন an issue of jurisdiction with regard to the maintainability of the writ petition before this court has been raised by the respondents. Stop. Next. It appears from the documents annexed to the writ petition that the husband of the petitioner was a resident of Kuch Bihar and his information of death was communicated at his residence, which lies within the jurisdiction of this court. Stop. The permanent residence of the petitioner, who is the spouse of the deceased employee, falls within the jurisdiction of this court. Stop. Accordingly, comma, the issue of jurisdiction as raised by the respondents fails. Stop.
My lord, may I?
Let the affidavit.
He died in Tufanganj. Communication of death was not given to him. He died in Tufanganj, but while he was serving, was he posted at Tufanganj?
May not be posted, but then at least a part of the
My lord,
cause of action
proving
are
of
also
his-
there.
Nobody is disputing his death.
No, you cannot dispute.
And even if the death is proved, how does it help the case of the petitioner?
The
Petitioner
petitioner
cases
is
that have
reside. Petitioner
petitioners,
resides over here.
right, my lord. But the order was passed in Pune. The order that the petitioner's challenge was passed in Pune.
ওই লাইনটাও লিখে নিন the order impugned rejecting the prayer of the petitioner was also was passed in Pune, which falls outside the jurisdiction of this court. ঠিক আছে একটা জাস্ট লাইন যেখানে বললাম যে এমপ্লয়ি ওয়াজ রিসাইডিং ইন তুফানগঞ্জ কুচবিহার so at least it can be said that a part of the cause of action, that is the death of the employee, arose within the jurisdiction of this court. ঠিক আছে আচ্ছা the affidavit shall be prepared and served upon the learned advocate representing the petitioner by 2nd February. Will it be possible? No. 9th of February. 9th of February.
We represent
exception-
1 to 5, my lord.
1 to 5.
We represent 1 to 5.
Is there anybody else?
Yes, my lord, I think your lordship will also need an affidavit from the information commissioner.
No, it is your officer, commandant for.
Up to 5 we are there, we will file our affidavit. up to
Yes,
5.
you will file your affidavit by 9th. Exception, if any, may be filed by 20th of January. List in the available circuit bench.
Grateful.
Next available circuit.
Grateful.
Ha ha ha.
Lord, I beg to appear on behalf of the petitioner, Lord. Lord, this is the second round of litigation, Lord. Kindly takes up page 12, running page 12 of the writ petition.
Yes, I want the rest.
Running page 12 is the order of Justice Shubhra Ghosh, Lord. Page kindly takes up page
13, my lord.
Yes.
Having considered the submissions made by the learning council on behalf of the parties, then material, I dispose of the petition with a direction upon the respondent number 12 to consider and dispose of the petition filed by petitioner dated such and such within a period of 3 months from the date of communication of the order, after giving reasonable opportunity of hearing to all the affected parties, including in accordance with law.
What happened after
My lord,
23rd of
thereafter, my lord,
November
kindly takes
22?
up page 15. The reason order has been passed, my lord. Order dated 23rd of November 22, my lord.
What happened thereafter?
My lord, in the said order, my lord, observation has been made that plot number kindly takes up order.
What happened after this?
My lord, plot number joint field inquiry was conducted by the in presence of revenue officers such and such, plot number such and such of the petitioner were affected by construction, my lord, measuring about, and plot number 1564 is not recorded in favor of the petitioner. Hence ordered that measuring land measuring about such and such has been used, and plots of land belonging to the petitioner are required to be acquired by the petitioner should be compensation as per relevant act and rules. Officer in charge such and such is to take necessary action. Thereafter, my lord, plot number 1564 I have recorded in my name, my lord, at annexure P4, page 19. My lord, the Khatiyan number, Khatiyan, from the Khatiyan, my lord will find Nam Manik Sarkar, Dag number 156. Page 19, my lord, annexure P4. Page 19, annexure P4.
1564.
Yes, my lord. Dag number 1564 is recorded in the name of petitioner, Nam Manik Sarkar, my lord. Therefore, I am entitled to get the compensation, my lord.
The other compensation you have received?
Yes, my lord, received.
Yes.
Oh, worship in this matter.
Please come. The petitioner is aggrieved by the observation of the Special Land Acquisition Officer Kuch Bihar, recorded in the order dated 23rd November 2022, mentioning that plot number 1564 is not recorded in favor of the petitioner Manik Sarkar, Manik Roy Sarkar.
Manik Roy Sarkar.
Stop. The petitioner has annexed the copy of the record of rights in respect of plot number 1564, which appears to have been recorded in favor of the petitioner Manik Roy Sarkar. Stop. Paragraph. The petitioner submits that as the record of rights in respect of plot number 1564 is recorded in favor of the petitioner, comma, accordingly, comma, the petitioner is entitled to receive compensation on account of acquisition of the said plot of land. Paragraph. Next. The petitioner is directed to forward a copy of the record of rights and the copy of the order passed by this court in WP number 3622 of 2018 on 23rd September 2021, and copy of the order dated, now copy of the order sheet in respect of the proceeding initiated by the Special Land Acquisition Officer, including the order dated 23rd November 2022 for taking necessary consequential steps in the matter after taking into account the record of rights relied upon by the petitioner in respect of plot number 1564. Stop. Next. The Special Land Acquisition Officer may give an opportunity of hearing to the petitioner. Stop. Next. Necessary consequential steps shall be taken in the matter by the Special Land Acquisition Officer at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Writ petition disposed. Service taken on record.
Grateful, my lord.
For the state, my lord.
For the state? What is the matter about?
But it's related to tender, mas.
Tender? Is the tender concluded?
My lord, regarding tender, regarding his suspension, page 31, your lordship.
Where is the petitioner?
Since he failed to pay the additional performance guarantee.
Ankon Mitro? Mr. Dhar? Nobody is here. Anybody appearing online or anything? Mr. Dhar? Are you the Mr. Dhar? I don't know whether there are any other Mr. Dhar or not.
My lord, the matter was supposed to appear on 29th of January, my lord. As per their service notice.
Over here it is mentioned 24th. Do one thing in that case, record an order. None represents the petitioner at the time of call. Stop. Learned advocate representing the respondent submits that as per the notice given by the learned advocate for the petitioner, comma, the matter is due to appear on 29th January 2024. Stop. Next. List on 29th January 2024. If the phone number is there, please contact the learned advocate so that somebody can represent.
Lordship, I am on behalf of the petitioner in item number 19, my lord.
Yes.
This is my affidavit of service.
What is the matter?
I'm for the state, my lord.
The petitioner is working as
Who is for GTA?
5 minutes ago, I received.
So what? Please wait and see what happens.
is working as teacher in charge of a government aided high school, which falls within the jurisdiction of Gorkhaland Territorial Administration. Now, by a application issued by the state authorities, which is Annex 27, the recruitment examination for the headmasters in the GTA area from state level test of recruitment to the post of headmaster and headmistress lordship. And moreover, lordship, DI has already recommended that as the that is the state level recruitment test is not effective within the jurisdiction of the Gorkhaland Territorial Administration. So those TIC, that is the teacher in charges, who having the educational qualification and other experience, be appointed as headmaster. And accordingly, I have made a representation at page number 20, my lord, and that has not been added till that. And in this regard, lordship, kindly come to page number 23, my lord. This court has passed this the order regarding representation to be
So you want
reconsidered.
page 20 to be considered?
Lordship.
Very well, please.
Similar
come.
order, lordship.
For lordship, the headmaster post is single get post lordship. If there is a the vacancies or not lordship, that has to be ensured by the.
Please come.
Let it be.
The petitioner claims to be serving as teacher in charge of a school under the Gorkhaland Territorial Administration. Stop. He seeks consideration of his representation in the light of the orders passed by this court from time to time. Step next. Without entering into the merit of the claim of the petitioner, comma, the instant writ petition is disposed of by directing the principal, comma, Department of Education, Gorkhaland Territorial Administration, to take a decision on the representation filed by the petitioner in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of this order. Stop. Next. It is made clear that this court has not entered into the merit of the claim of the petitioner, and all points are left open to be decided by the aforesaid respondent at the time of consideration of the representation of the petitioner. Stop. Paragraph. Learned advocate for the petitioner is directed to forward a copy of the representation dated 13th November 2023 and the copy of the orders of this court relied upon by him at the time of communicating the order of this court. Disposed. Service taken on record. Is the next one same?
Same, my lord.
Give me the name of the date of the representation.
Lordship, I'm giving
Is it the same?
affidavit of service. No, lordship, different date. Date of represent is 11th November 2023, my lord.
Representation item 20 same. It is 11th of November 2023.
Lordship, this is my affidavit of
Service taken on record.
Both of your lordship, your lordship. I have missed my appearance, lordship, for responding to national higher. I have given.
No, but then it was recorded in the order that nobody represented.
No, lordship, I was in court, but I have.
I do not know, it is recorded already. What can be done? Things are going online. So only giving a not serve.
So I will just forget to give sleep, lordship.
Were you present in the?
Yes, yes, lordship.
I do not know.
No, play this matter, lordship.
I do not, even I don't have a role to play.
Lordship, only my name should record, lordship matter. Goes off, lordship.
I don't know now. Who is going to check the live streaming and see? And next one, 21, who's there?
Yes, yes, your lordship, in pursuance of the order dated 4/9/2023, I have presenting the supplementary affidavit as the High Court judgment was required. This is the writ petition for granting remission, your lordship. And this court asked me to file the copy of the judgment of a High Court. Kindly accept.
Where is Mr.
Your lordship?
Little bit fast more, my lord. Mr. Raman is in his legs, court number 2.
Your lordship, 26 years in the prison.
Why did you not serve? In September 23, the direction was given.
In the last occasion, I was asked them, he submitted that at the time of hearing. Please give me the copy.
Well, this is not done. See, you affirmed it in November.
My lord, I am duly asked him. Well, he said that at the time of hearing, please give.
What is, let him come. I'll pass it over for the time being.
Grateful.
Yes, yes, your lordship.
And you give a copy to him in the meantime.
My lord, I was not in petitioner appearing in this matter. Lordship, there was a direction upon me on the last occasion. Lordship, to take a specific instruction from my client where the papers are lying. Lordship, she was called in the school and he has given all the documents and papers are not lying with him. It was with the school authority regarding the pension. Now, so far, Lordship, the decision which was concerned on the last occasion I was showing your Lordship, the passed by the directorate. Lordship, kindly come to page 17. Lordship, what has happened here, I came to know from this particular decision that the sanction which was earlier granted for the refixation of my salary, that has been cancelled by the executive authority while passing this particular order, the reasoned order. There was a direction to pass the reasoned order for granting this pension in my favor. But this reasoned order was passed. Lordship, kindly come to paragraph number 5. The petitioner submitted that he would send the written notes within 13/9/2021. I'm reading from page 17. Accordingly, sent his written notes on 11/9/2021 through email. The representative of the District Inspector of Schools, Alipurduar, submitted
that the matter should be considered in accordance with law. For proper adjudication of the matter, it would be pertinent to quote the written submission of the petitioner through email. Lordship, this kindly come to see on the basis of the application by me dated 12/4/2009, the Managing Committee of the Alipurduar High School resolved the Additional District Inspector of School Alipurduar be requested to accord an approval for higher pay scale if admissible, and consequent upon that I was awarded next higher pay scale, that is by additional district inspector of the school Alipurduar, wide memo number such and such. Now this pay band was fixed. Now Lordship, kindly come to the page number 18, last paragraph. He submitted necessary, this is a submission from the authority. He submitted necessary pension application and hard copy on 6/12/2018. After scrutiny by the concerned Deputy Director of Accounts, Alipurduar, the file was sent to DPPG Uttar Konna, but DPPG Uttar Konna returned the pension file to the concerned District Inspector of Schools, Alipurduar, raising some objection with a note that Sri Bhaumik was not eligible to get scale of pay band 3. BP was 7,100 to 37,600 GP, rupees 3,900. And he did not complete diploma course in library science. Lordship, this objection was raised by DPPG. Thereafter, Lordship, kindly come to paragraph number, page number 28, page number 20, last paragraph. Thus, the matter for higher scale of pay as sanctioned by the Additional District Inspector of the Schools, Alipurduar, in the light of notification number such and such, is considered from this end in accordance with law and is cancelled in accordance with law. Now, is it permissible? Lordship, they were considering my application for pension. Now, while considering my application of pension, they have cancelled this particular approval which was granted by the same authority earlier. Whether it is permissible under law, that is the question, Lordship, to be decided. If the pension is to be released, it has to be released. Immediately, I am ready to take the pension. I have given the papers.
No.
While considering this, they cannot pass this order.
Now, there are two issues. First is the validity of the portion of the order you read out at page 20, whether it is possible to cancel the scale first, and second is, where is your service records?
With the school, Lordship. I was called by the school day before yesterday. I went there. It is with school.
Has the school admitted that it is with them?
They have intimate. I met the headmaster. I went to the school day before yesterday, and these are with them.
Because
it was
as
DPPG.
I have a
observation.
I have another. Yes, I have another copy which was furnished to me yesterday only.
Yes.
This was something which he had, which the petitioner had on his side. He entered this login ID and password, forwarded the file to the head of the institution. That was done on 23rd. After forwarding it to the head of the institution, that was duly forwarded to the DI on 23rd itself. Subsequently, it was noticed that the name, that the date of birth of the spouse of the petitioner has been wrongly entered by him, and he made a prayer to the head of the institution, calling for the file back. This is the prayer of the.
So right now the file is with the head of the institution.
Right now the file is lying at the end of the District Inspector of Schools. District Inspector of Schools will return the file back on account of the said error which has been committed by the petitioner.
All right.
Well, kindly have a look at that.
The date of birth of the spouse was wrongly incorporated in the e-pension file.
Sent to you today. Well, that was
very well. So at least the file has been traced out.
It was lying at his end, as I had earlier mentioned.
Whatever. So right now the file has been traced.
Now it has been sent to the up to the DI.
Very
now
well.
The file is lying with the DI. The DI is to return back the file to the HOI for carrying out the necessary corrections in the date of birth of the spouse of the petition.
That is something very technical.
Yes.
But thing is whether you could have cancelled, the Commissioner of School Education could have cancelled the scale that was issued to the petitioner, taking into account his qualification. This has to be decided.
That order has not been challenged in this petition.
In the present,
look at the prayer.
This is not under
This is
challenge.
not under challenge in this writ petition. My lord, kindly,
That is not challenged.
that is at page number 9. A writ in the nature of mandamus.
Yes. Where is the prayer? Have you challenged that
This has not
action?
been challenged.
Lordship, this order may not be challenged because Lordship, I want the pension. If the pension is better,
Listen.
they can cancel it while releasing the pension.
You have to accept the scale which the commissioner has fixed.
Yes, madam.
Then you cannot.
Earlier thing, the cancelled one, Lordship, because pension is the continuous.
Listen, scale of pay which was given to you has been cancelled and you have been reverted to a lower scale of pay. You admit it and you want the pension to start.
Lordship, I have not admitted. I challenged the entire whole thing. I said the pension should be there at the earlier scale.
That is not reflected in your prayer.
Never.
Lordship, it may not be my prayer. This court has ample power to mold the prayer, Lordship. Kindly consider this.
Challenge. If you do not challenge that, it means that you accept the order dated 21st of September 2021 and let it be proceeded.
Which I am facing, Lordship, that I am right now, I have no penny to leave. That is the problem. That's a real hardship I am facing, Lordship. That's why, Lordship, let the pension be released. And I will challenge this portion. If Lordship grants me liberty, I will challenge it.
Give you liberty. Please come.
Nothing. Not making.
The petitioner prays for a direction upon the respondent authorities to take steps for releasing his terminal dues in terms of the order passed by the Commissioner of School Education on 21st of September 2021. Step next. The petitioner retired from service on 30th of September 2019. Stop. As there was an anomaly in his scale of pay, he is yet to receive his terminal dues. Stop. Next. The petitioner is aggrieved by the order passed by the Commissioner of School Education on 21st September 2021, whereby the scale of the petitioner stood revised. But as the petitioner has not received his terminal benefits till date, accordingly, he makes a prayer before this court to direct the respondent authorities to take steps for proceeding with his prayer for releasing the terminal benefits. Stop. The petitioner, however, reserves his right to challenge the cancellation of his pay scale.
Higher pay scale.
Higher pay scale. Higher pay scale. At a subsequent date. Stop. Next paragraph. Learned advocate representing the state respondent submits upon instruction that the e-pension file of the petitioner will be returned from the office of the District Inspector of Schools to the school authority for rectification by the petitioner, as the date of birth of the spouse of the petitioner was wrongly incorporated in the e-pension file forwarded by the petitioner. Stop.
My lord also kindly records, my lord, this particular application, this was lying at the end of the petitioner. This was forwarded only on 23rd, after the direction passed by this court on the last day.
23rd of January?
23rd of January. It was lying at his end. The pension was lying at his end. He logged into the portal.
The learned advocate for the respondents points out that the e-pension file of the petitioner was all along lying at the end of the petitioner, and the same was forwarded and the same was logged in by the petitioner on 23rd January 2024 and thereafter forwarded to the
HY, then thereafter,
to the head of the institution,
and thereafter to the DI,
which was
forwarded to the DI.
subsequently forwarded to the district inspector of schools. Stop.
This particular submission may not stand because of this particular order was passed with that file.
কি বললাম? ঠিক আছে, তারপর on detection of the error, comma, the necessary correction is required to be made by the petitioner himself. Stop. Next paragraph. The petitioner is directed to rectify the defect in the defect that has been detected and forward the same to the head of the institution for onward transmission to the district inspector of schools.
Grateful, Lordship.
Paragraph. The district inspector of schools shall take steps for releasing the terminal dues of the petitioner in accordance with law at the earliest, but positively within a period of 8 weeks from the date of communication of the 8 weeks from the date of forwarding the e-pension file to the district inspector of schools.
Grateful, Lordship.
Next হচ্ছে the respondent authorities shall ensure that the terminal dues of the petitioner are released at the earliest, but positively within 4 months of receipt of all documents from the petitioner and the head of the institution. Paragraph. It will be open for the petitioner to challenge the cancellation of the higher scale of pay if permissible in law. Disposed.
Grateful, Lordship.
Grateful, my lord.
My lord, I appear for the writ petitioner. My lord, there are two directions. On 17th November 23, my lord, the Honorable Coordinate Bench was pleased to direct the state respondents to come with necessary documents. And subsequently in December, my lord, there was a direction upon me to add the respondent, private respondent as party respondents. My lord, I have added, but my lord, my learned advocate on record is not sure whether it has been sent or not.
I see the edition is here.
Edition is here, my lord. He is saying that he has sent, but
Where is the service? There is no service.
he seems to have misplaced it, my lord.
Then serve afresh because nobody is appearing. Had anybody been appearing, then it would have been all
Yes, my
right. Acha. There is no proof of service of the writ petition upon the respondent numbers 4 and 5. Stop. Next. Let service be effected upon the non-appearing respondents. Stop list in the next circuit.
Grateful. Chalo, Aisha, chalo.
My lord, I am for the petition. My lord, the service has not been made to the union till date. I have gone through the my clerk. He has not served it. So Monday accommodation be given. I am served in the meantime.
The union is present over here.
Yeah, I will serve it today.
Copy, he says that he has not served. Very well. Service upon the union is not complete. Stop. List on 30th January. Service in the meantime.
That's item number 25. I'm appearing for the petitioner. My lords, before my lords is order under section 129 of the CGST Act, my lords. Detention case, my lords. The long and short of the story, my lords, is that on a transaction which was non-taxable, the respondent authorities under a proceedings under section 129, they determine my tax arbitrarily. On the basis of such calculation, they specify the penalty, my lords. Let me give you a brief
Is
background.
the respondents present? All?
Yes, fine.
Yes.
My lords, my excavator, facts in a nutshell is that my excavator, which was a JCB machine, which was belonging to me.
I see an issue order was been passed by the appellate authority
Yes, my
also.
lords. It is at page number
73.
65, 65 onwards.
73 date of the order.
My lords, operative part, I'll take you.
Yes, please.
Page 71, my lords.
Right.
My lords, there was a notice, my lords, before that, I'll just give you a nutshell, my lords. There was my excavator, which was belonging to me, was being returned by a person whom I had hired the same after the job was being completed. So it was a non-taxable supply. I also placed them a notification which stated that such kind of interstate movement is not a supply. The appellate authority considered that and said, kindly take page number 71, my lords.
Yes.
71 in the middle, my lords. The appellate has referred to circular 21/21/2017 GST dated so and so.
Yes.
The fact that the movement of goods was in pursuance of a transaction which is not taxable is irrelevant and inconsequential. Where it is a mandate under the provision of the GST Act that there should be a delivery challan accompanying the goods in movement for reasons other than by way of supply. My lords, this in my humble submission is a wrong interpretation of law, my lords. My lords, what happened, my lords? I had generated a challan. On the basis of that challan, I had also generated an e-way bill which was valid. That is not under dispute. My goods was detained on the sole premise that the challan was not signed by the consignee. Subsequent to that, a show cause notice was issued to me. I filed a writ petition before the High Court, first writ petition. In the meanwhile, they passed the adjudication order. I email also them to keep this proceedings in abeyance. They do not consider that. The writ petition was after that it was disposed of, giving a direction to me because challenge under that was detention order. So writ court directed me to apply for provisional release of the goods, which I complied, and subsequently I filed the appeal. Now, in the appeal, they hold this, my lords, I have stated. Now, my lords, kindly take for a moment section 129 of the Act, my lords. My lords. And this has also already been decided, my lords. I'll place judgments as well. 129(1). 129(1)A, my lords. Notwithstanding, later
129.
1A.
Yes.
Notwithstanding anything contained in this act where any goods transport, where any person transports any goods or stores any goods while they are in transit in contravention to the provisions of rule made thereunder, all such goods and conveyance used as the means of transport for carrying the said goods and documents relating to such goods and conveyance shall be liable to detention or seizure, and after detention or seizure shall be released. My lords, I am concerned with A, on payment of penalty equal to 200% of the tax payable on such goods. And in case of exempted goods, the amount is 25,000, my lords. So, my lords, the expression used here is of 200% of the tax payable. Now, kindly take 129(3), my lords.
Yes.
129(3) states, my lords, the proper officer detaining the goods or seizing goods or conveyance shall issue a notice within 7 days specifying the penalty payable. So in my humble submission, my lords, power under section 129(3) is only limited to specifying the penalty payable, which has to be done on the basis of tax payable on the said goods, my lords. What the appellate authority has done, he is saying that it is irrelevant and inconsequential. When there is an invocation, I am only on the quantum of penalty, my lords, because in my case, it was not a taxable supply. So therefore, in my humble submission, maximum penalty that could have been imposed was 25,000 as per the Act. And alternatively, my lords, my submission is also that kindly take section 126, my lords, which is general disciplines related to penalty. My case squarely falls under 126(1), my lords. It's a minor breach. Because tax payable is less than 5,000 rupees.
I didn't get it. What?
My lords, 126(1) states, no officer under this act shall impose any penalty for minor breaches of tax regulations or procedure requirement, or in particular any omission, mistake in document which is easily rectifiable and made without fraudulent intent or gross negligence. In the explanation part A, my lords, they have explained a breach shall be considered minor breach if the amount of tax involved is less than 5,000. One more submission, my lords. Kindly,
Where do you get that your taxable amount is less than 5,000?
my lords, I had given them a notification on the basis of which notification also I have annexed, my lords, if
Yes.
lordships will take. It's at page number 77, my lords, of my writ petition. This was placed before the appellate authority as well as the adjudicating authority, my lords. Second paragraph, my lords. The issue pertaining to interstate movements of rigs, tools and spares and all goods on wheels like cranes was discussed in GST Council's meeting held on 10th November 2017, and the council recommended that the circular so-and-so shall mutandis apply to interstate movement of such goods, and except in cases where movement of such goods is for further supply of the same goods, such interstate movement shall be treated neither as a supply of goods or service or supply of service, and consequently no IGST would be payable on such movement. My lords, what they have done, my lords, I will take you through the assessment order. They have valued my goods, my lords, under a 129 proceedings, which in my humble submission cannot be done. My lords, kindly take page number 43 of my writ petition, which is the first order, my lords, of penalty order.
Yes.
Paragraph number 10, my lords.
Yes.
Valuation of the above noted goods is done by considering the tax invoice purchase bill produced by the driver of the vehicle at the time of physical checking of the goods. Then, my lords, they have calculated in 11, they have calculated my tax for determination of penalty at the rate of 18% IGST, my lords. In the table, you can see. On the basis of this calculation, they have specified 200% penalty, my lords. So, my lords, in my humble submission, this is a clear case of excessive jurisdiction. And, my lords, kindly take rule 138(1), my lords, how they can value this consignment. Everything is specified in the rules, my lords. Kindly take section 1, rule 138, my lords. 138, sub rule 1, explanation 2, my lords. This. For the purpose of this rule.
1 minute. Rule 138. It must be over here also.
Explanation 2, my lords.
Rule 138.
Sub rule 1, explanation 2.
Yes.
My lords, are you, for the purposes of this rule, the consignment value of the goods shall be the value determined in accordance with the provisions of section 15, declared in an invoice, bill of supply, delivery challan, as the case may be, issued in respect of the said consignment, and also includes the central tax so and so, if any, and shall exclude the value of exempt supply. My lords, now kindly take section 16, my lords, 15, because it has to be determined as per the provisions of section 15, my lords. I am concerned with section 15, subsection 5, my lords.
Yes.
Notwithstanding, my lord, section 15 is the value of taxable supply, how they have to calculate the taxable supply. Subsection provides that notwithstanding anything contained in subsection 1 or 4, the value of such supplies as may be notified by the government on the recommendation of the council shall be determined in such manner as may be prescribed. So, my lords, read with this notification which has been issued by them, the consignment value of my goods should have been 0, my lords.
All right.
My lords, I am only on the quantum of penalty which has been imposed in this case. Completely arbitrary exercise of power, my lords. And my lords, I have also judgments of coordinate bench as well as division bench, my lords, this court, where this issue was considered and the matter was sent back to the authorities for passing a fresh. This is a coordinate bench and this was a division bench judgment.
But then here nothing was decided.
Yes.
My lords, here they have erroneous reasoning, my lords. I'm against the appellate authority, my lords, kindly appreciate. The appellate authority says that tax is inconsequential. My lords, how that can be, my lords? My lords, this is a division bench judgment.
Has it been decided? Has the issue been decided?
No, again sent back.
What's the use of just relying up?
Judgment, the issue has been.
Yes.
And my lords, there is a judgment I want to rely on the Allahabad High Court judgment in which it has been held that under a 129 proceedings, you cannot determine tax. What they have done in my case.
Yeah.
Because the provision is clear, my lords, and this was amended in 2021. Before that, there was a provision for calculation of tax under 129. Subsequently, it was amended, my lords. Kindly see in the book, it will be in 129, my lords, there was an amendment in the 129.
Calculation of tax.
129. The power is only limited to specifying the penalty amount, my lords. They could have initiated proceedings under section 73 or 74, my lords, which was not done in my case.
Oh, fine.
$129 was amended by my lords, by the Finance Act 2021 with effect from 1/1/2022. Prior, this was the
That is subsection 2 only. 129(2).
my lords, clauses A have been substituted. Clauses A, there was a specific,
1A.
yes, my lords.
Yes.
Previously, there was a provision of calculation on payment of applicable tax and penalty equal to 100% of the tax payable on such goods. So earlier there was on payment of applicable tax and penalty. Now they have amended and they have said on payment of penalty equal to 200% of the goods payable.
So, but
they have
then
made it clear
129(3) permits the specifying the penalty
on
payable.
the basis of tax payable, my lords.
Yes.
So much, my lords, but the power to determine tax is under section 73 and 74, my lords.
Let me hear what your learned friend has to say.
My lord, he says that the writ petitioner was transporting his own goods from one place to another. Now, when this vehicle was intercepted, the driver did not have any document with him. It is their case, the driver lost those documents. So there is a violation of Rule 138A, where it is mandatory that he should be carrying physical documents with him. One. At the time of verification, my lord.
Yes.
At the time of verification, he produced the documents.
Yes.
It had an e-way bill. The delivery challan was not signed. So as per section 55 of the GST Act, it is mandated that the delivery challan must have a signature, which was not there. At the time of appeal hearing, my lord, under 107, they produced the delivery challan. At that time, it was signed by whom, my lord? By the writ petitioner, but not by the consigner who has issued the delivery challan. Furthermore, there was a document, my lord, that's in page number 17 of the appeal order, 70, which says that a copy of letter dated 10/4/2023 regarding release of the excavator machine furnished by the appellant, which says that the excavator was released by Damesh, whereas the delivery challan was issued by PC Surya Singh. So validity of the delivery challan was under challenge, madam, and based on which there is a violation of 138 and they are liable to pay the penalty under section 129. Now, I have a Supreme Court judgment. Now, he's talking about that his goods being transshipped from one place to another and the penalty cannot be given, my lord. This is a Supreme Court judgment where in a very similar circumstances, goods was being transshipped from one place to another. What did the Supreme Court say? Cannot be the direction. I will just read it out. The court wishes to confine its consideration only to the quantum of penalty, as was made clear by order dated 8 December 2022. It is not in doubt that stricto sensu, the appellant cannot shrink from his responsibility of complying with the requirement of law to generate a fresh e-way bill, if for any reason the consignment has not been transported. However, viewing the factual scenario, which is not disputed, the appellant is the owner of the consignment and was using it in connection with its contractual obligation in Uttar Pradesh and then having a similar contract in West Bengal. This was a case of West Bengal. And no evidence has been placed on record that shows that the consignment was to be sold, used for any other purpose in respect of any other person. This court is persuaded to interference. The appellant has been saddled with a tax amount of 54 lakhs. The law also provides for imposition of penalty. Ordinarily, we may have refrained from interfering, but because there was an e-way bill that was generated and view of the discussion made herein above, we are inclined to vary the order passed by the High Court. In our opinion, end of justice would be served if the penalty amount is reduced to 50% imposed.
My lords, this is in my lords, subject to correction. I am aware of this judgment, my lords.
I'll come to you. Let her finish.
Sorry,
Yes.
I apologize.
Yes, please.
According to this, relief, if they want, can be granted.
Can be granted.
Fine.
That means the authorities have the power to evaluate the tax,
Yes.
which the petitioner is
Dis-
not accepting
Yes.
or rather
My
disputing.
lord. As per 50% tax, the Supreme Court has reduced, my lord.
So what is the tax amount over here that has been calculated?
18%, my lords. Arbitrarily they calculate, my lords. I showed you at page number 43.
That 18% is all right, but the amount has been the penalty amount has been reduced in this case, my lord. As
My
per
lord-
this judgment, if a direction may be given to consider
May I furnish my reply, my lords?
their representation, my lord.
For the Supreme Court
Is there
judgment,
a
my lords.
representation?
No,
Is there a representation?
No.
I don't think so. I don't see.
no, there's no representation.
Yes.
Against the appeal order. My lords,
Appeal
this,
order.
this order which she is placing, my lords, I'm aware of this judgment. In this is against the interim order which was passed by the High Court, just for getting the goods released. So in that portion, my lords, the Supreme Court said, okay, pay 15% and come. And here, my lords, I'm against the appeal order.
No, they have released the goods in that
That
judgment.
is all
No,
right,
that
but
is not
no, that is
disputed.
not is my dispute, my lords.
No, whether the
As per
Uh,
this judgment.
no, not for this, according to the judgment, according to the provisions of law, whether this tax could have been at all imposed or not.
Yeah, it can be
My lords,
imposed by
same issue,
That is the
cognizant
type of
decision of this court. My lords, same order has been passed. This has been for exchange of affidavits on the same point which I argued before, my lords. This is pending in the list, my lords, also today. Same issue was taken up for affidavits, my lords. In this case, I filed the writ petition against the directly against the penalty order. I filed the writ petition. It was admitted with an observation, my lords. Kindly.
With the direction for filing opposition.
Yes, my lords.
What is there to
Yes,
file
my lords,
opposition?
exactly. There's nothing left, but
Nothing left.
but-
Because everything
but
is
can
on.
you
Yes,
see
my lord.
can you see
And
the
a
order?
recent order under 107 has been passed, my lord. And I have given the judgment also.
Uh, Can you please file a note type of thing, whatever you've submitted,
My lord.
so that it
My
can
lord,
be
I
taken
can do
into
that.
consideration? And
My lord.
I do not think there is any requirement for filing any opposition.
No, there's no requirement, my lords.
All points of law.
Yes, and we are not
decided.
disputing any facts.
No factual.
Facts and we
influence.
are on the same page on facts.
Yes, facts are ad item.
My lord.
Please
Only
come.
interpretation of law is involved, my lords.
Page 70, 71 is the impugned order, isn't it?
Yes, my lord.
The Joint Commissioner, this is the order?
My lords, page number
77.
65 onwards is the appeal order. Joint Commissioner, my lords.
Yes. The order passed by the Joint Commissioner, comma, State Tax Authority. Dated 27th of September 2023 is impugned in the present writ petition. Stop paragraph. According to the petitioner, the respondent authority does not have any power to adjudicate the quantum of tax under section 129 within bracket 3 of the Central Goods and Services Tax Act, comma, 2017. Stop. Next. The petitioner relies upon various decisions passed by this court in support of his submission. Paragraph. Learned advocate representing the state respondent submits that the authority does have the power to evaluate the tax under section 129 within bracket 3 of the act. Stop. Next. The respondent authority is directed to file a short note in support of the submission made. List on 30th, Tuesday will be all right?
I'm
Should
grateful.
I take back the judgment, my lord?
Yes, you can take it back. You can also prepare a note if you
My lord,
require a very
I
short one.
I will prepare.
The judgments.
My lord.
It will be open for the petitioner to prepare a note.
My lord,
Can make
service
a
may be
bullet
kept.
point note.
Service may be kept.
Yes, yes, yes. Bullet notes will do.
1 page.
1 page, not more than that.
Your service may be kept. on-
Affidavit of service is taken on record.
Item 26, I appear for the university online. Kindly excuse my non-appearance before your lordship.
And for the
Lordship,
Yes, so who are you representing?
you're the Maulana Abul Kalam Azad University.
All right,
lordship, I am appearing for the university in this matter.
Milord, the matter is very short. The petitioners, Milord, engineering student.
petitioners. All
Yes,
right.
Milord, they're fifth semester. Completed their examination, Milord, in part.
What does the part mean?
The admit cards, documents which the college was supposed to hand over to me to enable me to sit in the examination was not generated. The reason that there were technical glitches in the.
No defect, shortcoming
No,
on the
no,
part of the
nothing,
petitioners.
nothing. According to my instructions,
Lordship, I have 2 letters sent by the principal of the college. Lordship, in the first letter that he says that the examinations, it's a remote place and we face a challenge, and to release the examination forms of the following students, that is the writ petitioners, they could not release the forms. This is a letter of 2nd December. On 7th December, he changes his stance and he says, Your Lordship, most of the students submitted the fees before the submission of the semester examination form, that is on 23/11/2023, However, 4 of the electrical engineering students of 5th semester have not paid fees till 24/11/2023. Therefore, the college did not release the forms of these particular students. Accordingly, the university could not issue admit cards. In any event, Your Lordship, the examination is long over. Kindly allow me to use a short affidavit enclosing these letters where the stand of the college has changed from the first of technical glitches and they could not issue forms to the fact that since these particular students had not paid the examination fees, forms were not issued to them. Therefore, Lordship, the university cannot hold a separate examination once the examination is over. A separate examination cannot be held. Once the fees have been paid, the college is now taking up the stand of the students that for sympathetic grounds, they should be allowed. Which means we have nothing to do. We had declared the last day of issuance of examination form was 24th and till 23rd, these students had not paid. Subsequently, they must have paid their fees and accordingly, now the college has taken up the cause of the students, which is really difficult for the university. University cannot unilaterally hold a fresh examination for 4 students.
But the examinations are over and the petitioners have participated in the examination.
They could not.
No, they have not. They have not. They were not issued admit cards. They have not. Therefore, Lordship, my prayer is that I be allowed to use a short affidavit. Lordship takes up the matter where I can enclose the stand of the college. Lordship, the contrary stand that the college has taken on 2 occasions.
My
They are
instruction,
on record.
real students of the batch. So that whatever requires to be done, let them let the college hold an ad hoc examination for these 2 papers.
How can the college hold? These examinations are university examinations.
So God is there for the college.
They have not received. Who? They means your client has not received.
Well, my affidavit of service shows delivered long back.
January, there is a recording. Why don't you collect a copy? If you have a fight at the university, fight it out. But let the students continue with their career. Why are you?
Let him come back.
Lordship, unless they compete, unless they pass the 5th semester examination, they cannot take classes in the 6th semester. They have not sat for the examination at all.
They cannot appear in the examination because of some issues between you and the college.
Lordship, there is no issue with the university. The college has put on pressure tactics. They did not issue the forms in the case of these 4 students. And thereafter, after the fees have been paid, they have taken up the cause.
Semester of the 3 years, how many years course? 3 years.
4 years.
4 years. 4 years. This is the 5th semester. This is the odd semester. 6th semester is the year where they pass into the next year. 5th is an odd semester.
Of the
Lordship kindly allows me to use an affidavit.
Bachelor of Technology in Electrical Engineering course from the Shiliguri Institute of Technology under the Maulana Abdul Kalam
Abul Kalam Azad Institute, University of Technology.
Next paragraph. The petitioners are yet to be permitted to appear in 2 subjects in the
5th semester
5th
examination.
semester examination.
Lordship, they haven't sat for the 5th semester examination. I do not know how my learned friend is saying that they have sat for the examination. No admit card was issued to them because their forms were not.
Sit for 2 papers. For the remaining 2 papers, they were not allowed to sit.
Learned advocate for the petitioners stressed that for the first 2 papers, the petitioners were permitted to sit in the examination. But the remaining were not permitted. Stop.
Lordship would kindly record my submission that the college may have allowed, the university did not allow them.
University submits upon instruction that no permission was given to the petitioners to sit in the 5th semester examination on account of non-payment of fees.
Lordship, in our case, the fees are not accepted by the university. Forms were not supplied. Forms were not given. We therefore did not issue admit cards.
Non-issuance of
Admit cards.
admit cards by the college
As well as the university.
and the university. Stop. Next, learned advocate representing the college is yet to receive instruction from his client. Stop. The court is of the opinion that the future of the students is not jeopardized on account of any dispute arising between the college and the university. Next, the respondent authorities are directed to iron out the creases to ensure that the petitioners are permitted sit in the 5th semester examination. Stop.
Lordship, that will only be held in December of next 24. Odd semester examinations are always held at the end of the year, and the even semester examinations in the middle of the year. Kindly records my submission.
On the adjourned date. Service is taken. Service was possibly there on.
Great.
Lordship would kindly record my submission that the examinations are not held in middle of the year. Kindly record my submission.
You please come up with a written instruction, Ms. Mitro and Mr. Bhatt. Please.
If I may.
Lordship, may I?
Well, if I-
Lordship has fixed a date. Kindly fixes the date. I shall file a short affidavit also in the meantime.
I do not have any issue if he can come.
Well,
ready.
he will have adequate time in between.
Very well, 29th.
29th, Lordship, I shall file an affidavit in the meantime.
29th. In case you intend to file an affidavit, please serve it in advance upon the parties so that they also know what is your stand.
Grateful.
Lordship would kindly pass a direction to that effect that I.
Direction, you and college, please fight it out. 28, yes.
Millard's item.
Grateful to your Lordship.
Yes.
I'm appearing for the petitioner. Millard's service is defective, Millard's.
Services?
Defective.
Effective.
Millard's the page numbers and annexures is not mentioned, Millard's. I'm extremely sorry. There is also an analogous matter, which is writ WPA 84 of 2024. It was mentioned yesterday. Those both matters can be clubbed and kept next week.
What exactly is your prayer in the writ?
Millards, this is a case, Millards, where I am challenging the sanction order which has been passed for launching prosecution against me, Millards.
Sanction order itself is under challenge.
Yes, Millards, I have challenged the sanction order. Income tax case, Millards.
Yes, whatever. Can you do it by next week?
Yes, Millards, I am ready with the matter.
Learned advocate for the petitioner seeks time to effect fresh service upon the respondents. Stop. List on 30th of January.
Millards.
Service in the meantime.
Grateful.
You give the number so that the other
84.
matters,
Okay, I'll
analogous matters can come
analogous
up.
matter for the-
Please give your appearance.
Next.
Complete.
28 Millards, I am appearing for the petitioner. Millards, the short issue involved, Millards. This is a GST matter, Millards. There was an inadvertent error on my part in filing the GST return for the month of September, Millards, wherein I had made few inadvertent error wherein I had claimed less ITC. As compared to my books, I claimed less ITC. To outset the tax liability, what I did, I adjusted that from the outward liability, Millards, in the next month. This was reported by me in Form 9C, which is the annual return annual return is Form 9. Along with that, there is a reconciliation statement which is called 9C. I had submitted that. My consideration, my only grievance in this case is that, my lords, my 9C was not considered, even by the adjudicating authority as well as the appellate order, my lords. And my lords, I'm praying leave to file the supplementary affidavit, my lords. Annexure P3 is incomplete here, which is 9 and 9C, my lords. P3.
Where is P3? Which page do I get that?
My lords, it's at page number.
Rakho.
Notes nikalto. Notes.
34.
Yes, my lords. Page number 4, my lords, is from GSTR 9, my lords.
Page number 4.
Yes, my lords, this is the annual return. My lords, kindly take page number 6. Column number 6A, my lords.
Page number 6 of writ petition. No. Today's affidavit.
Page number 6 of today's affidavit.
Yes, my lords. This is my annual return which was filed, my lords. Column number 6A.
6.
Yes.
6A shows the total amount of ITC available, availed through Form 3B. This is 33 lakh and 7 lakh 13,000. Next column, my lords, B is the inward supplies, which is 35 lakh. There's a difference of 2 lakh, my lords, 2 lakh, 2 lakh. Then, my lords, kindly take page number 9, my lords. Page number 8, my lords. 8A. Column number 8A, ITC as per 2A. So my ITC as per 2A was 35 lakh, and I had claimed less, my lords. Then, my lords, come to page number 15 of my of this supplementary affidavit. This is the 9C form, my lords. This is the reconciliation statement. In column number, the upper portion, my lords, in column number P, the total amount to be paid as per the tables above 15.
15, column number
P.
P.
Total amount to be paid was 35 lakh and 41 lakh. And I had paid 34 lakh, 33 lakh. So this was the difference which I had not paid. And in the bottom table, my lords, 10A, I have stated the reason therein.
10A.
The difference shown is due to wrong entry in GSTR 3B in the month of September, and the same was rectified in the month of October 2017 by adjusting the output tax liability, my lords.
Now, what do you want?
My lords, I'll take you through the appellate order which is under challenge, my lords.
Page?
Which is starts at page number 67. Operative part is at
67 is your ground of appeal.
I'm sorry, my lords. From 69, my lords. 69.
Yes.
Paragraph page number 74, my lords. Operative part.
Page 74.
Yes.
From the middle, my lords. Thus, every registered person is liable to discharge outward GST liability. So, my lords, allegation against me is that I have short paid my self-assessed
GST.
Yes, my lords. To discharge outward GST liability self-assessed in Form 1 by reflecting the same in 3B and discharging the said liability through electronic credit ledger as per section 49, but the appellant did not reflect the total.
What is the penalty that has been imposed?
No penalty, my lords. They have charged the tax amount, which the difference amount. They are asking me to pay that.
What is the figure?
It's same figure, my lords. 4 lakh around. 2 lakh IGST, 2 lakh CGST and 2 lakh.
So, what is to be reconciled once again?
My lords, my submission is that
You have already paid.
Yes, my lords, and as per books, I had claimed. There was an inadvertent error. I filed my 9C. That was not considered, my lords. There's a principle of natural justice, violation of principle of natural justice, my lords. To that effect.
Yes.
And my lords, it was the initial days
What is your submission?
My submission is that, my instruction is that the amount which has paid by the petitioner is shortly paid.
No, that he admits.
Shortly paid. So he shall have to.
Shortly paid at that point of time, but thereafter he paid it up.
in that case, I have to take further instruction, and today
Why
he has
don't you-
filed,
yes,
some more documents.
right. Instead of taking further instruction, why don't you consider this document that has been
Yes,
filed, and if
but
if
I
it
want
is
that. Already appellate forum has already delivered his judgment.
Milords, kindly
Passed
see-
his order.
Hmm.
Now, regarding the inter-payment, I have to take kindly allow me to file affidavit in opposition, so that
Milords, facts I am not disputing, but subject to correction by my senior friend, facts I am not disputing, Milords. My only submission is that, Milords.
No, now the
very
issue,
short submission, Milords.
what the issue he is raising right now is after conclusion of the entire thing, can it be reopened?
Milords, kindly see page number
This is
74.
what he is.
Milords, kindly see page number
authority has
74.
already passed the order.
Kindly see page 74, Milords, last paragraph.
Yes,
74, last paragraph, Milords.
but the amount is not much. It's 2 lakh and odd.
Yes, Milords, and it was in the initial
Yes,
days of GST, Milords.
Yes.
Various decisions, various high courts have taken judicial note of this fact, Milords, because they had issued so many notifications, shown so many changes. So it took time for people to come up. Milords, there is a circular to this effect. I want to show that, Milords. This is very important to my
Please.
case. Page number 93, Milords. 91 onwards is a circular. These were the guidelines which were issued by the
Recovery.
central government, saying that you can directly recover the initiate recovery proceedings without going for 73 or 74 in cases where assessee have short paid taxes. So what they have observed, Milords, I would like to show paragraph number 3.2, page 92.
Yes.
There may, however, be some cases where there may be genuine reason for difference between the details of outward supplies declared in 1 and those declared in 3. For example, the person may have made a typographical error or may have wrongly reported any details or 1B or 3B. Such error or omissions can be rectified by the said person in subsequent 1 and 3B as per the provisions of 37(3) or the provisions of 39(9) as the case may be. There may also be case where supply could not be declared by the registered person in 1 of an earlier period, though the tax on the same was paid by correctly reporting the said supply in 3B. The details of such supply may now be reported by the registered person in 1 of the current period. In such cases, there could be mismatch between 1 and 3B in the current tax period. Therefore, in all such cases, an opportunity needs to be provided to the concerned person to explain the difference, if any, for short payment and non-payment. And next paragraph, Milords, they have reiterated the same thing. So even in their circular, they are stating that to consider these aspects, Milords, where there had been omission and mistakes on part of the assessee. So my only submission is that, Milords.
Now relying upon this.
My lord, I have a small submission. Against the order of the adjudicating authority, he preferred appeal as per section 107 of the CGST Act. Now, appellate authority has passed its judgment, and after the appellate authority, as per section 112, the assessee or petitioner shall have to prefer appeal before the appellate tribunal, which is going to be open. So far, our instruction which is going to be open within few months, as because in Delhi, appellate tribunal authority has already been established. In Calcutta, within a short period, the tribunal will be opened. So at this juncture, I think without any affidavit, if the petitioner is willing to continue before this honorable court, in that case, I have kindly allow me an opportunity so that I can file affidavit in opposition, as because if the learned honorable court will pass any order regarding his short payment or regarding his excess payment, in that case, the order of adjudicating authority is required to be set aside, and as well as the order of the appellate authority. So, without going to the entire facts and circumstances, the entire documents, it is not possible to adjudicate.
Very well. Tell me one thing. Did you raise this issue before the adjudicating authority?
Kindly take page number 63 of my writ petition, Milords. Kindly take page number 63. This is the appeal form which was submitted, Milords. Kindly see the uploading supporting documents. GSTR 9C. It was uploaded. 63 of my writ petition. My lords has got it.
9C.
Yes, my lords.
This is the rectification that you've made.
Yeah, this I am saying they have not considered. And page number 74, last paragraph, my lords.
Yes.
They are only relying on GSTR 9. They are completely silent on 9C, my lords. This is my case. 9C was not considered, my lords.
So this issue was not there before the adjudicating authority.
Adjudicating authority also I had raised this issue.
Show-
my lords. I will show you, my lords. My reply was page number 42, my lords. In fact, even in the order, my lords, they have reflected my submissions.
Please.
Page number 57 of the impugned order.
Yes.
My lords, the upper portion, second point.
Short claim, short input tax. Yes.
Second point, my lords.
Right.
Also, the output liability was short declared in 3B and subsequently reported in GSTR 9 and 9C for the relevant period as there was no option. These are my submissions before the
And
adjudicating.
how was this point?
They are not considered. 9C, they did not consider, my lords. Completely silent on 9C. Kindly see, my lords. Next page. Discussion and findings.
It is only GSTR 9.
Yes, only 9 they have considered.
Please come. The petitioner is aggrieved by the order passed by the adjudicating authority and the appellate authority in passing order without considering the submission made by the petitioner for considering the GSTR 9C, which was submitted by the petitioner. Stop paragraph. The petitioner admits that there has been short payment of short deposit of the tax due to inadvertence. Stop. The mistake was rectified by filing GSTR 9C. Stop. The same has not been taken up for consideration by the authorities. Stop. Next. The petitioner relies upon the guidelines issued by the Central Board of Indirect Taxes and Customs, dated 7th January 2022, relating to the recovery proceedings. Stop. Next. The guidelines mentions that there may be genuine reason for difference between the details of the GSTR 1 and GSTR 3B. Stop. The authorities, now the CBITC, GST policy wing mentioned in the guidelines that in all such cases, an opportunity needs to be provided to the concerned registered person to explain the differences between GSTR 1 and GSTR 3B, if any, and for short payment of the amount of self-assessed tax liability and interest thereon. Step. Next paragraph. It appears from the documents placed before this court that the petitioner relied upon the GSTR 9C in support of the short payment made by him. Stop. The same has not been considered. The same does not appear to have been considered by the respondent authorities. Stop. Next. In view of the above, the order passed by the adjudicating authority and the appellate authority are set aside. Stop. The adjudicating authority is directed to revisit the issue after taking into consideration the GSTR 9C submitted by the petitioner. Stop. An opportunity of hearing shall be given to the petitioner to place all documents in support of his claim. Stop. A decision shall be taken at the earliest, but positively within a period of 8 weeks from the date of communication of this order.
May I?
Supplementary affidavit filed is taken on record. Writ petitions
My
next
lord,
disposed.
my submission regarding filing of affidavit in opposition may kindly be noted.
Learned advocate representing the respondent seeks time to file affidavit in opposition. Stop. Next. As it appears that there is hardly any dispute in the factual aspect, and it is apparent that the submission of the petitioner as recorded herein above was not taken into consideration by the respondents at the time of adjudication of the case. Accordingly, keeping the writ petition pending with direction for filing affidavit will not serve the purpose. Stop. Accordingly, the writ petition stands disposed of with the following observation.
Grateful.
Following directions.
Grateful, my lord. Service may be kept on record.
Yes, service is taken on record.
My lords, I am appearing for the petitioner. This is a GST matter, my lords.
I'm for step.
What is it?
My lords, this matter is squarely covered by the division bench of this court, my lords. On the basis of 2A returns, my lords, my ITC claim was disallowed for assessment year 17-18, my lords. 2A, GST 2A, my lords, are auto-populated returns. The suppliers furnish their details. From there, it is auto-populated. So when I file 3P, I can match those returns, my lords. So, my lords, kindly take page number 35 of my writ petition.
Yes.
This was the first notice which was issued to me for production of books of accounts, and my lords will see that it is issued for the year 2017-18. And on two grounds it was issued. Firstly, it was on suppression of turnover, and secondly, it was issued on only huge amount of purchases for the period. There was no outward supply.
Where do I get those?
My lords, page number 35, point number 1 and 2.
Suppression of turnover and huge
These were the two grounds on which it was issued. Next page, my lords, page number 36. Kindly see the heading, my lords. Now, this was for 3 years, from 17-18 to 19-20. And I was directed to furnish all these documents, my lords. Next page, my lords, is the final report which was passed by the Deputy Commissioner of Revenue. Last paragraph, my lords, those 2 points which were issued before, that was, they were satisfied with that. The issue which they raise here is from the middle, my lords. During the period financial year 18-19, the ITC claimed on GSTR 3B was 17 lakh. Whereas as per 2A, it was only 14 lakh. Excess ITC is 2,71,000. It is apparent in the instant case he has claimed excess ITC of 2,71,000. Next page, my lords, you'll find the superior officer issue me a show cause notice. And finally, the order was passed at page number 46, my lords. I did not participate because it was uploaded in the portal. Same cyclo-styled order passed by the junior officers. It was copied, my lords. Same order. I file an appeal, my lords. My appeal was dismissed at page number 55 onwards is the appellate authority's order. 59 is the operative part, my lords. It's a completely non-reasoned order, my lords.
5 pages order and you say it is non-reason?
Milords, kindly see only one page
Statement
they
of
have.
facts. Such it is spread that in view of the I have gone through the face-to-face assessment or the case under the enforcement of initiating general and transfer to a
Provisions also they have wrongly quoted, my lord. 16.4 was not my violation. They have stated 16.4.
Page 59, which is as per provision of section 16.4, here is the government. Yes.
Milords, so I am a bona fide purchaser, Milords. I purchased goods from the supplier. They gave me tax invoices. All those invoices I furnished before the adjudicating officer as per 16.2, Milords, which states all the conditions for claiming ITC. I had satisfied. Milords, now they are charging me because my supplier did not pay tax, presumably. So on this aspect, Milords, there was a circular passed by their board, Milords. 2 circulars I am referring to, Milords. This was also considered by the division bench, which I'll place after this, Milords. Paragraph number 4 of 4th May press release, Milords. No automatic credit reversal of credit. There shall be no automatic reversal of input tax credit.
This press release was made by whom?
Milords, it was made by CBDT, Milords, Central Board, Milords. I have also specified in my writ petition, I have pleaded this. At paragraph number page number 14, Milords. Paragraph 16 and 17. I have pleaded this.
Page number 14. All right.
Paragraph 16 and 17.
4th May. 4th May, which point do you want to
Milords, on 4th paragraph.
4th
point.
No.
No automatic reversal of credit. There shall not be any automatic reversal of ITC from buyer on non-payment of tax by the seller. In case of default in payment of tax by the seller, recovery shall be made from the seller. However, refusal of credit from the buyer shall also be an option available with the revenue authorities to address exceptional situations like missing dealer, closure of business by supplier, or supplier not having adequate assets. Milords, then next press release, paragraph number 4, Milords.
Yes.
It is clarified that furnishing out outward details in GSTR Form 1 by the corresponding supplier and the facility to view the same in 2A by the recipient is in the nature of taxpayer facilitation and does not impact the ability of the taxpayer to avail ITC on self-assessment basis. In consonance with the provisions of Section 16, the apprehension that ITC can be availed only on the basis of reconciliation between 2A and 3B conducted before due date of filing is unfounded, and same exercise can be done thereafter also. Milords, then I am relying on the division bench judgment, which squarely covers my issue. Paragraph 9, Milords. इसका copy पे Paragraph 9. ये वही है. Same point, Milords. Paragraph number 9 is the operative part.
Yes.
The first respondent, without resorting to any action against the fourth respondent, who is the selling dealer, has ignored the tax invoices produced by the appellant as well as bank statement to substantiate that they have paid the price for the goods or service rendered as well as tax payable thereon. The action of the first respondent has to be branded as arbitrarily. Therefore, before directing the appellants to reverse the ITC and remit the same to the government, the first respondent ought to have taken action against the fourth respondent, who is the selling dealer, and unless and until the first respondent is able to bring out an exceptional case where there has been collusion between the appellant and the fourth respondent, or where the fourth respondent is missing, or fourth respondent has closed down the business, or fourth respondent does not have any assets or any other contingency, straight away from the first respondent was not justified in directing the appellant to reverse the ITC availed by them. Therefore, we are of the view that demand raised is not sustainable. So my submission is, and this, my lords, against this, an SLP was also filed by the department, which was dismissed, my lord. Although this was dismissed on low tax effect, my lords, so I cannot rely on this, but it was dismissed.
Yes, what is your
Yes,
submission?
In this matter, there are a lot of factual disputes, madam. We have to file our affidavits with regard.
What is the factual
There, first of all, there are 3 financial years. Number of first one, the proceeding was dropped. The third one of the subsequent proceeding was dropped. And the second one, where the petitioner's ITC claim was, there was difference in the ITC claim. He is saying that that is because I have sold to someone and I have taken it from those respondents. My instruction is otherwise. So I have to place it on affidavits.
How can your instruction be otherwise? Whatever your instruction is will be there in the order itself, the appellate authority's order, the adjudicating
They have never produced
you cannot have a new fact at this stage.
Not new fact, my lord, but they have also not produced any documents during the appeal period.
Which document?
According to the act, they have to produce the documents to substantiate their claim.
Yes, tell me which document
For that,
was wanting.
Yes, for that I need to seek instructions.
My lords, I showed you the notices, initial notices, which
I am doing it without instruction, my lord. If we come back with instruction, take it on next week.
No, nothing remains in this case, my lords.
At least let me have my instruction.
Please come. Heard the submissions made on behalf of the petitioners. Petitioner. Stop. Reliance has been placed on the press release of the respondent authorities on 4th May 2018 and 18th October 2018. Stop. Reliance has also been placed on the judgment passed by the Honorable Division Bench of this court in support of the submission made by the petitioner that it was not justified in directing the appellant to reverse the input tax credit availed by them without taking any steps against the
Respondents 5 to 14, my lords.
they were the consignors
They were the suppliers, my lords.
from against the suppliers. Stop paragraph. Learned advocate representing the state respondents seeks time to take instruction in the matter. Who are the private respondents, the suppliers?
Yes, my lords. I have made them a party, my lords, but my prayer is to dispense with Rule 26, my lords.
No, but then I don't think it is so very urgent that Rule 26 has to be dispensed with.
My lords, they are not the answering respondent. They are the answering
May not be the answering respondents, but if they come up and come with a different story, then it will be difficult.
My lords, they have my GSTN numbers, their GSTN numbers. They have the power.
Did you serve? Did you
Okay,
serve?
I did not serve, my lords. Because they were not the answering respondents, that is why I did not serve.
Paragraph the the service upon the private respondents have not been made till date. Stop. Let service be effected upon the private respondents. List in the next available circuit. Stop.
Okay.
The official respondents may take necessary instruction in the meantime. Learned advocate representing the official respondents may take
Grateful.
necessary instruction in the meantime.
I'm grateful.
May it please, Your Lordship. I am appearing for the petitioner in the matter.
GST 1 to 5, kindly give me 1 day account. Tomorrow I will contact them.
May it please, Your Lordship. I am appearing for the petitioner in the matter.
Item 4.
I
You
took
are there?
4 my lord.
You want time?
just 1 day accommodation.
1 day accommodation.
Or Monday, Tuesday, any day. Today,
Milord, then may I pray this? May I pray for the matter to be listed on Monday, my lord?
Very well.
If my learned friend is seeking an accommodation.
Seeing the state respondents.
No.
But may I only indicate the fact so that my learned friend may take instructions and come back on Monday? Otherwise, my lord.
Seeks time to take instruction in the
1
matter.
to 4, respondent number.
Respondent numbers 1 to 4. Seeks time to take instruction in the matter. List on 29th, that is Monday. What about the respondent numbers 5 and 6? Are there you are
Respondents 5 and 6 are the pro forma respondents, my lord.
yes. Come back on next day.
Good.
Yes, service is taken on record.
My lord, may I only pray this that if the matter retains its position in the list, my lord.
They are in the same position, don't worry.
I'm very deeply.
Let your lord.
My lord, for item 21, I am for the petitioner, my lord, led by Mr. Pradeep Kumar Mittal.
Who is for the respondent?
My lord, Mr. Rahman Yal.
Please. Mr. Maminur Rahman. What is the matter, please?
Your Lordship, I am in confinement for last 26 years, and it is my humble prayer that for the time being, I be granted the interim bail in purview of the order passed by the Supreme Court, that is Annexure P3 and P4 at page 20 and 21, Your Lordship. Supreme Court, while considering the petition for ransom, granted interim relief.
On page number 20, 21.
20 and 21, kindly see, Your Lordship. And your Lordship, I have submitted the representation also, but till the date they did not consider it, not decided. On 12th January 2023, I have submitted the representation. What is granting them? Page number
been charged under
302.
Yes, ma'am.
What is the age of the petitioner?
Now about 40, yes.
And
now about
for 25 years.
20, more than 20.
Yeah, at the age of 10 years, he committed this offense.
No, my lord.
What no?
No.
Who is the?
At present, he is about 40 years, Your Lordship.
Oh, he is the age of. He is the sister of the present petitioner.
Yes, Your Lordship, and now he is completing, I think, more than about almost 27 years.
Informed by way of a supplementary affidavit today that the appeal that has been preferred by the petitioner hearing against challenging the conviction, the appeal has been rejected.
Appeal has been rejected.
This is the order.
Then where is the scope of granting?
That is the thing. He has been directed to undergo entire period of sentence.
Yes, where is the scope of releasing him?
No, Your Lordship, kindly let me clear. Your Lordship, supplementary affidavit was filed because this court wants to see the judgment of the High Court. High Court judgment has not been modified. The order of the trial court has been affirmed. Your Lordship, my prayer is that since 26 years has been passed in the jail, therefore I submitted the representation before the state for granting remission, as in which is the power under West Bengal Service Correction Act. This government has power to grant the remission, and I have submitted the representation. But till the date, 1 year passed, but my representation has not been decided. Therefore, my humble prayer in view of the order,
You
my
have
humble prayer that
of law according to which this revision can be despite
pardon your
rejected.
Your Lordship, first I have approached the Supreme Court for granting remission. The Supreme Court directs me to approach the state. I submitted the representation in January 2023, but not decided. Therefore, I approached this court by way of the writ, and I filed two annexures, P2 and P3 at page 20 and 21. In view of the longer custody period, Supreme Court granted the bail to the accused of 302 interim bail and directed the state. Thereafter, Supreme Court directed the state to consider the representation of the convicts. Kindly see P3, page 20 and
state
Well,
person.
21.
There is a policy under which there is a board which decides the remission of convicts.
Where
But
is
that-
that board existence? Does that board exist?
Yes, that board is periodically conducts its meeting. One of the last meeting that was held was the 65th meeting, that is of the State Sentence Review Board. And this was held on 14th of July 2021. And
21.
subsequent thereto, the next meeting is due to be held. It is not yet held.
Let me see what instruction. Is this your instruction? You have already filed it?
Your Lordship, I have humble submission that my case is also identical as the case of Ramji Dubey and one other petitioner whose order I have filed on the record before your Lordship. Annexure P3 and Annexure P4, page 20 and 21. Interim bail has been granted in such identical matter, your Lordship.
That was interim.
Thereafter, this court granting the bail may direct the state to consider my representation.
What I have submitted before your Lordship is the constitution of the Sentence Review Board, State Sentence Review Board. And my lord, as per the 65th meeting, the case of the petitioner was duly taken up.
Was taken up?
It was taken up. Has a look on the next page. There's the name of the petitioner reflected, and it was rejected on the grounds that has been mentioned.
Name is Akalu
Paswan.
Akalu Paswan. Name of the convict. Paswan, I don't see. Remaining one is there.
Akalu Paswan.
Akalu Paswan. Premature release of the life convict may cause breach of peace in the locality.
That was the ground on which it was rejected. This is the decision. This was the decision taken in the 65th meeting, which was held in 2021. July 2021.
Tell me, is there any appellate authority of justice? Nothing.
Only the one option, that is writ, your Lordship. And
Taking
I submitted the
offense committed and his conduct while
Please
he
come.
was undergoing sentence.
Please come.
Your Lordship, kindly see as at page 41, the jail authority mentioned that my behavior is good. Conduct and behavior is good. At page 41, your Lordship, custody certificate. And I have also given undertaking that I will live peacefully in the society, and on my part there will not be any such act.
The petitioner.
Yes, your Lordship. Some difficulty in voice, your Lordship.
By the Honorable Division Bench. On
Of the Supreme Court.
2005. Stop. Paragraph. Learned advocate representing the petitioner submits that his client is in custody for more than 25 years. Stop. Prayer was made on behalf of the made by the petitioner for remission of his sentence. Stop. The petitioner's prayer was taken up for consideration by the State Sentence Review Board, West Bengal, for consideration of premature release of life convicts on 14th July 2021, and his prayer stood rejected on the ground that premature release of the life convict may cause breach of peace in the locality as opined by the police authorities. So, the relatives of the victims are apprehensive about the repetition of such crime. Stop. Next. The petitioner relies upon the order passed by the Honorable Supreme Court
20 and 21.
in the matter of
It was
Rashidul Zafar
Yes, Your Lordship.
and in the matter of Ramji Dubey,
Yes, Your Lordship.
annexed at pages 20 and 21 of the writ petition. Stop. Next.
Yes.
The court is not convinced with the submission made on behalf of the petitioner. Stop. Genuine reasons have been mentioned for not accepting the prayer of the petitioner for premature release. Stop. Next. In view of the above, no relief can be granted to the petitioner in the instant case. The writ petition fails and is hereby dismissed.
grateful.
Supplementary affidavit been on record. এবার, হ্যাঁ, 30 ঠিক আছে। Nobody is there? None repre
I'm for the state, my lord.
petitioner is not.
Copy not served.
Copy not served.
No, my lord.
None represents the petitioner at the time of call. Stop. Learned advocate representing the state submits that copy of the writ petition has not been served. This is a revision. Copy will not be served.
No, my lord.
Why will it be served? Revision, it's only after it's admitted that the copy is served. There is no scope for servicing copy.
My lord, we don't have any copy, my lord. So but it was not endorsed to anyone, my lord.
How can it be served? Achha.
No, this is not admission.
ওই লাইনটা কেটে দিন তো, কপি has not been served, ছেড়ে দিন। প্রথম লাইনটা থাকবে নন রিপ্রেজেন্স, পরের লাইনটা কেটে দেবেন, ঠিক আছে? লিস্ট ইন দি নেক্সট সার্কিট। What do you want? Well, let it be admitted first. Let us see what is there. Please. Why quashing? Why? What is the ground of quashing?
Actually, on 8 March 2023, some railway track was shifted from AGP station, and it was loaded in the ground. Subsequently, this petitioner registered a case, detained the truck, and arrested and further seized all the articles. After departmental inquiry, it was found that one video footage was hidden. That's why he was departmental prosecutor and convicted, directed him to release, directed him to compulsory retirement.
Compulsory retirement.
He compulsory retired from his service.
All right. Where was he serving? Where was he serving?
This is not my issue. My issue is after when he retired from his service, thereafter the authority arrested in his. He lost the affair and he is arrested in.
Yes.
And thereafter he got the bill. I am seeking for quashing of this.
But then I do not find any ground for quashing it. Why should it be quashed?
I lost the complaint.
Yes.
I am prosecuted in my own case first. I will see the FIR lodged. FIR lodged by the petitioner, RSP.
Page.
I just missed the petition. That's why I will spend one day admonition. One day admonition.
Learned advocate for the petitioner is not ready. Stop. List on Monday, 29th. Tomorrow.
I'm trying to.
Tomorrow. Kalke দিয়ে দিন, 25th. Same. Ready? Yes. What is the matter?
This is the I'm challenging the order passed by the learned judicial magistrate Passport Gurulasan. And that order was confirmed by the civil judge for calling for directed petitioner to pay maintenance of ₹7,000 in domestic violation act.
What is the ground for quashing? Why should the why? Why? What is the
Actually, this lady is previously married to another person. She claimed that I am petitioner is the husband of the lady.
the learned trial judge as well as the appellate court has gone through all the details. So there is
I
no
am satisfied after.
no prior to issuance of notice you have to satisfy. Then only notice will be issued. Why will the person come here if the court is not satisfied? Yes, I have seen the impugned order.
After page 42 onwards.
Yes.
In appeal, they did not, our ground that lady was previously married with another person and he has one, but divorce was not found. Thereafter, she is the just servant of this petitioner. The house subsequently she claimed that she is the wife of the.
There is children out of the relationship. And now you say that she is the servant only to avoid paying maintenance. No, I'm not.
And the lady who have children. They already, she already married, she has already one daughter.
I can see the court has taken into consideration all your submissions regarding earlier marriage and everything. So what is the reason of keeping this pending? Not taken into consideration? Have you checked up? I have seen it has been taken into consideration. Maybe.
Earlier marriage is there and divorce not complicated, but the company is treated as a partner.
See your submission that she was married with one Robi Limbu and her marriage is subsisting.
Yes,
so that has been taken into consideration.
but divorce is not perfect.
She stays in the shared household. Paragraph number 12. Has married because his wife is suffering from mental illness and bedridden for 10 years. Her name is recorded in the voter ID card, the Aadhaar card, and they stay together as husband and wife. Sorry, please come.
Kali admitted that you are satisfied at the time of hearing.
No. The petitioner is aggrieved by the order and judgment dated 14 December 2023 passed by the sessions judge at Kalimpong in criminal appeal number 5 of 2022 arising out of miss case number 84 of 2022. Stop. Next. I have paragraph there. I have heard the submission made on behalf of the revisionist. Stop. I have perused the order passed by the learned trial court and the judgment delivered by the learned appellate forum. Stop. The submission made by the revisionist that the earlier marriage of the revisionist is still subsisting and direction could not have been passed for payment of maintenance to the respondent number 1 was duly taken into consideration by both the forum. Stop. Next. The learned courts below were of the opinion that the revisionist would be liable to pay maintenance. Stop. Next. The paragraph. This court does not find any infirmity in the said in the judgment passed by the appellate forum. In view of the above, there is no reason to interfere in the present revision application. The same stands dismissed. $33. Yes. Next week. Seriously? Then next week. On the prayer of the learned advocate representing the petitioner, list in the next circuit. Seriously? Take rest. Who is there? 34? Yeah, what is the matter? On the prayer of the learned advocate representing the petitioner, list in the next circuit. $35? What happened? Seriously? Then next circuit. Yes.
In this case, I have challenged the appointed lordship for the quashing of the event. Of the case is concerned, equal lordship can see the paragraph number 6 of the. Actually, this is the matrimonial dispute between the de facto complainant as well as the wife of the petitioner number 1. And she lost a
De facto complainant and the wife of the petitioner number 1.
de facto complainant is the wife of the petitioner.
De facto complainant is the wife. Yes.
Number kindly see so for the paragraph number 6 is concerned.
Yes.
She lost the complaint against the petitioner number 1 and her mother-in-law as she was induced by her other relative. Subsequently, case was initiated, and the case was initiated for which section? 307 and 350. And the matter was ended in charge sheet. The case was initiated in the year of 2021. That is 30th August 2021. Now, can you see the page number 14?
Yes.
One certificate within our waitlog period on 11th October 2022, the de facto complaint as well as copy number 1 gave birth a child because we are living together happily. Even after lodging of that case, she realized that she had committed a wrong. She came to my house and we resumed our relationship. And so my humble submission to the lawsuit, the matter may be admitted. And if the lawsuit case may be the data process may be said and I will produce, or she may appear voluntarily, that is the option number 1, with your lawsuit to honor that.
The case was lodged on 12th of June 2021. And childbirth.
Childbirth was 11th October 2022. Immediately after initiation of that case, she realized that her husband is innocent.
No, realize the husband is innocent. 98, 307.
And we resumed our relation. And we are blessed with this.
Please come. The petitioner seeks quashing of the FIR and charge sheet. Stop. Next. Let notice be issued upon the respondents. List in the next circuit.
Maybe state that.
No, not staying. 498 a proceeding, no staying. Next circuit. What is the matter?
My lord, in this matter, I am challenging the procedure of proclamation by which I have been already declared as proclaimed person by the learned additional judicial magistrate. My lord, the basic facts of this case is that
Don't go to the facts. Tell me what is the error.
the error is, my lord, that on 8th May 2023, the magistrate ordered for the proclamation process and directed the office to comply with the publication. But my lord, in subsequent orders, there is no mentioning of the publication. On such day, my lord,
Where is your client?
client is presently at his house.
In his house. Why doesn't he go and surrender?
My lord, he tried to surrender, but my lord, his name was indicated in this case from the statement of acquirement.
Why doesn't he go and surrender? There is a proclamation against him. Why doesn't he go and surrender?
My lord, if he, the whole process is being instituted only to stand behind the bar. My lord, there is also a breach in the investigation process. My lord, further I will enter into the matter.
You go and surrender first, thereafter everything will be done. The petitioner is aggrieved by the
Then my lord, kindly few days accommodation, my lord, surrender so that I can.
is aggrieved by the order of proclamation passed against him. Stop. Next. The matter is directed to appear in the next circuit. Stop. In the meantime, the petitioner is directed to surrender before the learned court of the ACJM. Which court he?
Yes, SCJM Mecklenburg. My lord,
Comma Mecklenburg.
the statutory period of 30 days not even needed to appear before the.
You go and make all submissions. First you surrender, then we will see what is to be done. Yes. Next.
For hearing, item 38, WPA 294.
Why? Let me see the file once. By Shaler. Where is the opposition?
Lordship, this matter was appearing before the principal bench. We have been informed by the department that already it has been filed. They have also received the copy, but on the last occasion also, we need to check the record.
No, because I see from records,
Lordship.
it is dated. It is dated 20th of September 2023, which mentions that liberty is granted to the parties to file the affidavit in opposition and reply, and then to mention the matter.
Lordship.
And it was passed here in Jalpaiguri itself.
Lordship.
Then
It came because department instructed that already it has been filed before the principal bench. They have probably, senior also mentioned that they have received the copy. Because this case was earlier connected with Ghosh. He has returned the brief because he is not in the panel.
I do not see any of the orders passed in the principal bench all over here in Jalpaiguri.
It came from probably.
This is Kumar Shomendra Narayan.
Lordship.
There is nothing to suggest that the matter was taken up by the principal bench even once. All orders are passed by this bench. Are you aware of anything?
Then we will pray for next circuit because we have to check up the record first. We have to call.
In that case, costs will be imposed.
Because in Jalpaiguri
18th of February 2022, 2 years, nearly 2 years. So pay costs.
Lordship, actually, in this case, Mr. Vikramaditya Ghosh was conducting the case. He has led the panel. He has written the brief few days back.
I'll fix it on Monday. Right? In the event the opposition is not there, then be prepared for costs.
No, sure.
Who is the respondent?
Respondent, hey,
DM Kuch Bihar.
DM Kuch Bihar.
Union of India, who is representing Union of India? You are not answerable. Very well, but then you are representing the Union of India. An accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Learned advocate representing the state respondents is not aware as to whether the affidavit in opposition as directed to be filed by order dated 18th February 2022 has been filed or not. Stop. It appears from the order sheets of the instant writ petition that time to file the affidavit was extended on repeated occasions. Stop. Next. List on 29th January 2024. Stop. The parties are directed to come ready with all necessary instruction.
Last order in principle, annexure P6, which you lost direction for every filing. And I'm this.
Also 39, Lordship, may I be permitted to move through virtual mode? Lordship, this is a writ petition filed by a teacher, Lordship, for his notional benefit. Lordship, kindly come page 28. The recruitment process was started in the year 2003. 2002 petition, 2002 petitioner was called for verification of his testimonials. Petitioner appeared. Now, Lordship, the petitioner's name was, from the M-panel, petitioner's name was struck down. Kindly come page 31. Initially, I moved the writ petition.
Please tell me one thing, whether the affidavit which was directed to be filed has been filed or not.
Lordship, they have filed everybody in opposition, the chairman of Lordship Jalpaiguri District Primary School Council.
What about your reply?
Now, Lordship, there are two writ petition was filed in the same identical facts, because all these four petitioners, four persons, Lordship, they were empaneled in the 2003, but the appointment letter issued in 2016. So, Lordship, I have lost my Lordship, the seniority as well as the notional benefit. Now, in the other writ petition, this court directed to the Commissioner of School Education to consider my prayer. Lordship, on terms of this order, the other three petitioners already given chance of hearing, and this is waiting for order. Lordship, I am praying for same identical fact, the same identical order that directing the Commissioner of School Education to consider my grievances, Lordship, regarding the notional benefit. Now, Lordship, the same order may be passed.
Where is that order?
Lordship, the order WPA 2187. This order was passed on 22nd November 2023. This order was not with me, but Lordship, the order is there, directing the Commissioner of School Education to consider my prayer regarding the notional benefit. Lordship, kindly come page 31. Kindly come page 31. The order was passed. Subsequently, in 2012, this writ petition was disposed of, directing the Commissioner of School Education to consider our case for approval of the panel. Now, Lordship, this approval has been given. Our name has been forwarded in 2013.
but chairman has approved the same in 2016. The appointment letter was given on 28th November 2016. I filed an application.
Tell me one thing, I see some office note wherefrom it appears that this matter is due to appear before the principal bench. Is it so?
It was initially heard in the principal bench. That
And
is correct.
there was a direction for placing it before the principal bench once again?
Initially it was directed to appear before the principal bench.
So why has it come back to the circuit bench once again?
Lordship, the circuit bench, it has been sent automatically. This is not in my instance.
Automatically?
Yes, Lordship. I never mentioned this matter, but matter has been sent to the circuit bench. It is unusual term.
I see Mrs. Gangopadhyay has ordered the matter to be placed before the principal bench. The matter has been wrongly sent to the circuit bench, Jalpaiguri. The chairman who was here, please.
After the direction for affidavit, there is no order that the matter will be appear before the principal bench. The order direction for order is there. They file the opposition.
একটু চেক করুন তো দেখুন তো এটা আমি দেখতে পাচ্ছি যে ওখানে রয়েছে অর্ডার রয়েছে ফর প্লেসিং এর পেছন দিকে দেখুন লে নোট রয়েছে এটা একটু দেখে নিন It is being passed over for the time being. Let us see what happens. No, better Bishwajit Babu, এটাকে কালকে রাখছি. I'm making it only not today, only for the appended to the file that the writ petition was due to appear before the principal bench. Stop. The registry is directed to check up and place a report before this court. It's on 29th January. 40.
Your Lordship, I'm appearing for the petitioner, Your Lordship. I'm led by Mr. Robi Shankar Chattopadhyay.
Yes.
Lordship, I'm praying for not this week.
Why?
He's unable to join this meeting, Your Lordship, due to some personal difficulties. Kindly make it not this week.
Who is
I'm from the status.
this is IC the tender matter.
No, this is basically.
Tender
But
matter.
affidavits have already been exchanged.
No, but then is the tender over?
Yes, that
Period of tender is also over.
Yes.
Then what remains? Is the petitioner successful in the tender?
But what I find from the affidavit is that, as well as from this, with the direction passed by another writ petition hearing was granted to the petitioner. The order was not. And challenging the said report. Page 67.
65.
Annexure P5.
$65 is the order of this court.
67.
67.
Annexure P5.
29. He decided.
Capacity of the godown.
Is the private respondent appearing?
Yes, the private respondent was appearing.
Who is appearing for the private respondent? Jui Datta Chakraborty, 12, 13 and 14. Please record an order. Learned advocate representing the petitioner seeks accommodation for this week Stop. None represents the private respondents. Stop. Let notice be served upon the private respondents intimating that the matter will appear in the list on 29th of January 2024.
Grateful, Your Lordship.
Yes, please.
There was a direction in the month of May. Today, opposition is being
served. Pay costs.
Lordship, before
And this is one minute. This opposition on behalf of the Alipur Jila Parishad. Jila Parishad is the answering respondent. What is the only point?
only point is this contractor has already been terminated.
Yes.
Apart from other reliefs, termination also challenged. Termination, notice was served in the form of recommendation. But it's ultimately termination. Now, to terminate, to suspend, some procedure has to be followed.
Opposition has been filed. Do you intend to go through it and come back by filing reply, or can we proceed with the hearing?
Lordship, only 2 days.
For filing reply?
If necessary.
If necessary. This I see was affirmed on September. Why did you not serve?
My lord, I was
copy?
under the impression, my lord, wrongly that it has already been served upon him.
In September, there is a direction.
Yes, I can see.
It was immediately affirmed thereafter. My
And
lord,
copy not served.
I was under the impression it has been served. It's my bad.
Then
my
it
lord.
is absolutely wrong impression. See, the matter is getting delayed.
Well, it's appeared after September for the first time and is being taken up today.
If it is in opposition filed on behalf of the respondent numbers 3 to 6 is taken on record. Stop. Copy of the same has been served upon the learned advocate representing the petitioner in court today. Stop. Next. Learned advocate representing the petitioner seeks time to go through the same. Stop. List on 30th of January.
No, Lordship, either it will be convenient for me to
29th? 29th? 29th.
Grateful.
হবে না কেন হ্যাঁ ওইখানে তো যাবে আমি তো সেটাই দেখলাম দেখেই আমার মনে হলো তো যে ফাইলটা এলো কি করে এখানে ফাইলটা এখানে এলো কি করে একটু খোঁজ নিয়ে দেখুন তো ইয়েস
Very important order was passed on 13th June 2020. Subsequent to that, there was the same case where I had raised the issue of determination of tax under a contingent proceedings. And a very good order was passed in my favor. We were not satisfied with the interim order, so we approached the division bench, led by Chief Justice in the division bench. There was a direction by the Chief Justice to let this matter after. And this is the last paragraph.
Yes.
Subsequently, this was there is no evidence have been filed. Several orders have been.
In the light of this, we have left no option. We are left with no option except to dismiss the appeal since the vehicle is no longer in custody. Has the opposition been filed?
And my goods are still lying inside. That is the difficulty. And when I was in short, I'll tell you.
1 minute. Opposition, state, Dilip Kumar Agarwal. Where is he?
Find him today because most probably he is ill or something.
Who is he representing? Taxing.
GST authority.
Taxing authority.
State tax authority.
Now I'm going to impose cost.
Madam, kindly keeps it and tomorrow the holiday. Tomorrow the holiday.
The vehicle.
Monday, Malad kindly keeps it on.
The vehicle is lying with the taxing authority. Or where is it? Before
Yes,
the.
it's with them.
It's with them
Yes.
for quite some time. The vehicle has simply worn out.
Yes.
Then what remains?
And because my second-hand car, they treated it like a first-hand car and imposed a lump sum penalty amount. It was completely arbitrary exercise of power.
I'm going to impose cost. Where is the learned advocate Dilip Kumar Agarwal?
Malad, he has not come today. Most likely he is ill or something. Malad, I'll just.
None represents the state respondents. Stop. Repeated direction for filing affidavit in opposition has not been complied. Stop. Paragraph. Learned advocate representing the petitioner submits that his vehicle is lying in the custody of the taxing authority on and from
Not 14, 15, it's filed on 2023.
15th of May 2023. Stop. List on 30th January 2024. Stop. Let a notice be served upon the learned advocate representing the state respondents, intimating the next date of hearing. Take back this order because I see this is already there in the file. ওপরেরটা ফেরত দিয়ে দিন।
Next item, Lordship, next item 43 and 45. I tender my apologies to Lordship, there is a direction for evidence. Income tax matters, so many matters. I have filed in several matters, in two matters. Lordship, kindly fix that second. Within second, your Lordship, I have filed the evidence.
Lordship, may extend the seventh revision.
Lordship, there is, you have this one, 43 and 45. So many
1 minute, one by one. 43. 43.
July, without direction is done.
12th of July, I see.
This matter will not see, will search out who are the faceless hearing.
Order was passed on 12th July 2023 for filing affidavit in opposition. Stop. The same has not been filed till date despite repeated extensions were granted for filing the same. Stop. Today, learned advocate representing the income tax authority seeks extension of time once again for filing the opposition. Stop. For ends of justice, time to file the affidavit in opposition is extended peremptorily till 2nd of February 2024. Stop. Reply, if any, may be filed by 9th of February. List in the next available circuit. 1 minute. 44 will be called first. 1 minute, 1 minute, let it be called.
For the statement.
44? Yes.
Copy? Reply? Yes. Reply. Why? Let him appear online. You are there. Let him continue. Yes, yes. Please start.
But basically,
Hmm.
half the bank for long 17 years.
17 years.
And after that, he was suddenly suspended. And which was started because for but in pendants of the proceeding to start. In fact, he along the kids are facing the menace of starvation. Without any somebody, without any parent, without that. You know, in fact, I mean, now to page number 21.
Yes.
Where he was asking the
Asked to?
appear in an interview for the job.
Page 21 is a transfer certificate, I see.
P1.
Yes, it's a transfer certificate.
I'm sorry.
Lordship, may I permit one point, your Lordship, in case.
Yes.
Lordship, in this case, jurisdiction point, we have raised the jurisdiction point at first.
We
Sonali
means?
Bank.
We means?
The Sonali Bank, your Lordship.
Sonali Bank?
Yes, the petitioner is the employee of the Sonali Bank, Bangladesh.
Bangladesh?
So, your Lordships, we have first day raised the question, the point of jurisdiction. The Sonali Bank is not under Article 12, your Lordships.
It is mentioned office is at Lelin Sharoni, Kolkata.
The office, just office. International Bank, stated meaning ashen.
National Bank as approved by the Reserve Bank of India. And the Honorable is our court as of that.
Yeah, Sudip to the
So many times. Yes.
It's a private
bank, purely private bank, your Lordship.
So not Bangladesh Bank?
Bank of
Bank of Bangladesh.
Maybe the Bank of Bangladesh.
Which has branches here in Siliguri as well as in Kolkata.
And
It's a
then
private bank.
but then it is discharging public functions.
Yes.
No, no, that he's trying to take of that judgment of the Honorable Supreme Court, but that is not.
It is our preliminary point, your Lordship.
I understand, but then if it is conducting public function?
Yes.
And Calcutta is
no public functions are needed.
What type of function does this bank do?
Public
He's a sub-staff, he's a sweeper, he's a both guard staff. Actually, security branch. And if they raise this point, both the resident bank, class of the bank, whether 226 is applicable or not, I'm reading that.
Yes, because that is the issue that has been raised. The first issue, maintainability.
The two judgments, one of justice and 30%. And another of the last second one another is these three judgments are satisfied. Yes, 26 is very much applicable. So far, Sonali Bank. These are the judgments.
I can see one over here, Justice Bhattacharya. Is it Messrs. Pierce and Drums and Barrels?
Yes. It Pierce and Drums, right?
Please show how it will be maintainable over here.
Paragraph number 1.
No, this I have. It is Justice Bhattacharya's order. It actually.
Either small and medium enterprises between 6 and it engages in business or manufacture and supply of various barrels to the oil sector and various other sectors. In the report, there's one or four that is interest in the bank granted in municipal science. The interest in bank and the last observation, the respondent of both by starting from the domain of state to discharge.
Where did you read? Where, which portion are you reading?
The paragraph 34.
34. Yes.
Local bank market national income. You want to circulate the answer.
Para 23, below
23.
para 23 and para 24. Para 23, since the Reserve Bank of India is an instrumentality of the state, it comes squarely in the meaning of state as contemplated in Article 12 of the Constitution. Thus, the writ petition is maintainable. That apart, the function discharged by the respondent for bank are of public nature and as such pertain to discharge the public duties. The question raised by the petition is not restricted to the demands of the petitioner solely, although such demands forms cause the sign of the petitioner, but also have a wider conversation in so far as the liabilities of the banks are concerned in respect to the refund of the proceeding is concerned, and the objection regarding the maintainability of the petition is unparliamentary.
Second.
And if you refer the judgment of this, just in the last second month, which is Sonali Bank Employees Association versus Union of India. The writ petitioners are employees of the Workmen's Union of the Sonali Bank Limited, which is a foreign bank functioning in India under the license of Reserve Bank of India. Then very short judgment. According to the Indian Bank Association, Workmen's Union of India functioning in India, right that by 11 bipartite settlement. According to the 11 bipartite, I can go to the bipartite settlement. That is me. However, in deviation and derogation of say bipartite settlement, they defied the regulations of bipartite settlement. Despite service of notice, Sonali Bank they are not to be present before the scope evidence of service by report is taken on record. The presumption that follows that the statements and allegations remain uncontroverted. Hence, Sonali Bank the India operational intelligence service rules shall remain state for a period of 6 weeks from it. So the petition was it.
Thereafter, this was in 21. What happened thereafter?
It is yet to be disposed of.
So it has not been decided.
Never challenged it. Bank has never challenged it. Bank has not questioned the authorization of government.
Is anybody representing the bank over here?
Sonali Bank. Last Sonali Bank was represented by the lawyer.
Who is the lawyer? Who is the lawyer? 1 minute. Who is the lawyer representing the bank?
Yes, now
Mr. Mazumdar and you were together?
Mr. Mujumdar.
You are, that means you are representing the bank?
Yes, Your Lordship. First day, on one day I am representing the bank, Your Lordship.
So email was informed. So the list. This is the email.
Very well, they are present. The council is present. And what is the other judgment?
It may belong to this union. Sonali Bank's criteria. Sonali Bank's criteria. Is scheduled commercial bank in India under the supervision of RBI. Licenses are provided by the RBI. Functions like any other public sector banks. Members of the Indian Banks Association and other government statutory bodies. Head office Dhaka, Bangladesh, obviously. Branches 2, 1 in Kolkata, another in Sri. Head of the India operation is CEO and Deputy General Manager India operation. Function of CEO and Deputy General Manager India operation as per the power of attorney conferred by head office. Local based employees appointment authority is CEO and Deputy General Manager. So it's that all these things qualify. These 4 pages are sufficient. These are the granted license also there.
Where from did you get all this information? Where from did you get all this information?
What from the Sonali Bank authorities collected, my client has collected all these information. Because he is.
So what is the genuinity of these documents? This is only I want to see.
They don't deny this. Bipartite settlement, the name of Sonali Bank appears.
Yes, then what happened?
Well, this is a very important thing I need to refer to. This is according to the bank workman service conditions. This is according to the bipartite settlement dated 10/4/2002. And according to these foreign banks, the Sonali Bank comes as number 51 of the category.
Let me see. All right.
I come to the factors, yes.
Yes,
Now,
please.
page 28.
44 data.
27 and 28, Alexa P3 appointment. I was given the appointment in December 27, 2005.
Yes.
And next 28, this is very important, Lord. Roman 8, small a.
27.
Next page. 3 copies of certificates in respect of your educational qualifications along with the originals for signing and verification which will be returned to you. These documents were submitted. Along with documents, my Aadhaar card, my school certificates, my voter ID cards, everything were submitted. Those were accordingly verified. And after verification, made we have present advising that you have been confirmed in your present grade by the certificate of sitting with effect from now this important next page, page 31. P6. Suddenly one good gentleman or bad gentleman, I would say, send an email to the bank without date, without the person, a well-wisher. I don't know who is the well-wisher or bad wisher. The employee Kambujaman already is working as a peon in Sonali Bank by being a certificate. Then date of birth is true. There is date of birth is 2/7/10/76. These all IT tools changed in accordance with this certificate. Other side is Murugan, this is Musundi, original birth certificate from India, I surgery school as school age subsidiary. This email was sent. I don't know who sent it to the bank authorities. And accordingly, on the basis of this letter, without proving the authenticity of the record, without creating any step as per law, he was asked to show cause. The show cause in Alexa P38 without initiating any disciplinary proceedings. So cause. And the branch manager, not the CEO or anybody else, not the higher official. The branch manager, Molla Samim of the branch manager, this is P8, page 38, asked him to show cause. And the reply was immediately given by the petitioner. This is page 39, P9. And the bank authorities, very unfortunately, without initiating any disciplinary proceedings, refer to the observations of the bank, the banking regulations, that the banking authority, if any irregularity is caused by a person, if any illegality is done by any employee, he has to so called and disciplinary proceedings has to be initiated. But without initiating any disciplinary proceedings, FIR was lost. Case was raised, this is page 40. the officer in charge, money can be outpost in the Metropolitan Police. And the case was registered. Petitioner obtained bail. And this thing and your see another aspect.
1 minute. Page 38 is the show cause. 39 is the reply to the show cause. Then 40 is,
Obtained the police station by bank authorities.
all right, thereafter 41 is the CEO.
This is the file, page 43. Formal FIR.
Formal FIR is page 40. Yes.
And 49.
45, 48, 49, yes.
48 and 49.
Right.
And my lord, this is very important thing. Again, I come back to page
Was any disciplinary proceeding initiated
No,
against
no,
you?
no, not at all. No disciplinary proceedings were initiated.
Show cause was there, reply to the show cause there.
But this much.
Thereafter, nothing.
Nothing.
Where is the order of termination?
No, it's suspension.
53.
Suspension is annexed P1153.
53 is the suspension.
Bank as well as 53 and 54. The branch manager and the CEO and deputy general manager. Which one should I accept?
This is the same thing, the branch
Same thing.
manager and the CEO and the
persons.
two persons suspending him. I'm sorry, good morning, and the father as per the letter of instruction. 2023. Yes, then what happened?
Then that suspension was challenged by me.
All right.
And during proceedings, they did appear, they filed written objection, they said that I'll file counter affidavit, this and that, it's going on. And suddenly, during the pendence of the proceedings, they terminated my job.
Where is that termination?
Termination. In reply, I've given the termination.
All right.
In reply. Page 15. Miller annexure P2. This is November 29, 23.
Yes. Dismissal from service. This is November 23. So, between May 23 and November 23, no disciplinary proceeding initiated?
No, not at all. No, Milord, one thing, with respect to the allegation, when I was asked to so call, along with the so called, I gave my school certificate to, issued from that school in year 22. The principal confirmed that the school certificate and the date of birth, as stated by the petitioner originally, that is correct. That is probably, I give your lordship, that is there. That is probably, yes, this is probably page 22. This was issued by the bank school authority again. Dated 23/7/22. Along with my so-called reply, this certificate I submitted before the bank authority, which was issued by the headmaster of the school.
Which
Kharera ANHM High School.
Which page?
Page 22. আছে না এখানে ওই যে না ওইটা ভাগ করে রেখেছিলাম দেখো এটা দিতে পারছো ওই মোটা পয়সা দিন না
Page 21 is the name of, is the transfer certificate.
This is the original certificate which was submitted by me at the time of my appointment. And this is subsequently when I was asked to show cause that your date of birth in that certificate is wrong. But that was confirmed by the bank school authority again. No, it was not wrong. It was issued on 2/3/90. And the subsequent is 23/7/22. I got the job in 2005.
23/7/22.
That because of floods, the reports and all were destroyed.
And moreover, another thing school authority has said that probably in 2000, devastating flood in the district of Murshidabad, and all papers were
washed away.
Water level reached
But
up
how
to
could they obtain these false certificates? I couldn't understand.
How could you obtain the 2022 certificate if
22, this 22.
Yes.
Not this. 22 means this was the way means the false person. But this thing, I may beg to refer this thing. This is there. That Budia High School. He said that Budia High School, he was a student of Budia High School. Budia High School. Page 32. Page 32, Budia High School. Where did he get it? This is really amazing. And moreover, the Budia High Schools, the authorities said that every part, this is page 37. No,
page 37. What?
In page 37, in reply to the letter written by Professor Bhattacharya Balaji Complex and in response to a letter bearing this number, this then sent by post subject notice and right to information act, right to inform as per admission registered Kamarujaman, this. In this connection, I'm sorry as I cannot provide the other information regarding said ex-student have been demanded by you in point 2 and 3 your letter because there occurred a devastating flood in the school area in that Budia school, not my school. In that Budia High School, along with other parts of Bengal in the year 2000, and all the documents have been ruined except a few number of admissions. This thing. So they could not substantiate it. They could not collect any document in support thereof.
Therefore, this document is
So this document is absolutely false, and the email is in fact absolutely suspicious. Nobody in the world can rely upon this email because it is a well-wisher. Who is well-wisher? No date, nothing of that.
general.
And it was written to the CEO and Deputy Chairman, handwritten, Michael Mullah Manson, Lenin Sani, employee Cambridge. How could this thing he collect it?
17 years
I've been serving there for the long 17 years. My all documents were verified. Since 2005, I have been in service. There were no blemishness in my service career.
Some years sweeper.
Both get stuff. My lord, if your lordship please to give me the book where the entire disciplinary proceedings have been enunciated.
In the writing fully English. Transfer. Admission. Are you getting a suspension allowance? No.
No, he was getting part salary during the suspension period, but after termination that was also stopped.
Oh, obviously, after termination, you cannot get it. But then till the date of termination, you got it.
I done this.
Yes. Yes. Next.
Next, the disciplinary proceedings.
Hmm.
The disciplinary action and procedure therefore. A person against whom disciplinary action is proposed or likely to be taken shall in the first instance be informed of the particulars of the charge against him, and he shall have a proper opportunity to give his explanation as to such particulars. Final order shall be passed after the consideration of all the relevant facts and circumstances to this object view. The following shall apply. Number one. Number two, by the expressed offense shall be meant by any offense involving moral turpitude for which an employee is liable to conviction and sentence under the provision of law. Number C. However, in the event of the management deciding after inquiry not to continue in service, he shall be liable only for termination of service with 3 months pay and allowance. That will also order. In your group. Next, if he prefers an appeal or revision, application against his conviction is acquitted. In case he has already been dealt with as above and he applies to the management for reconsideration of this case, the management shall review this case and may either reinstate him or proceed against him under the provision set out in clause 11 and 12. So by the expression gross misconduct, knowing making a false statement and all these things, this is the thing which I beg to refer to and give much stress upon, that a person who is in service for long 17 years without any prejudice, without any error, without committing any sins. It was terminated, was suspended and terminated without giving him any opportunity at all. Number one, without initiating any disciplinary proceedings at all. Number three, while this suspension order is being challenged before Lordship, before the Honorable High Court, without giving any care to the proceedings before the Honorable High Court, terminated. This is probably injustice. This is what we call injustice.
Very well.
And the person, an old man having kids, are in fact facing the menace of starvation. They've got no shelter, nothing of that. They're sleeping, they're in Siliguri from Murshidabad, and they're fourth-grade staffs, sweeper. And they've been victimized with this.
Very well, I have followed. Yes.
Lordship, kindly fix the matter in Monday.
Why?
Lordship, Mr. Mojumdar is the arguing counsel.
Yes.
With Mr. Mojumdar, Lordship, the senior.
Yes.
So kindly fix this matter Monday, we argue the matter.
Please come. Learned advocate. Learned advocate representing the petitioner commences and concludes argument. Stop. Learned advocate representing the bank seeks accommodation for the day. List on 29th. Our affidavit in opposition filed by the respondent numbers 3 to 5, 3 and 5, and the reply thereto by the petitioner be taken on record.
Item 45.
That's it. Lordship, so the item number 43 and 45 is same, your Lordship, related to. Second, your Lordship, I will file the affidavits. 43 and 44, please, madam, is your Lordship is the same, your Lordship. There is 5 matter in the same, we have already filed in 2. Within second.
Order was passed on 2nd of August 2022. 43 আপনি নিয়েছিলেন? 43 and 45 will be the same order, only the date of filing the opposition was given on 2nd of August. 45. ঠিক আছে? শুধু order for filing opposition was given on 2nd August 2023. Very well, same directions. Same as 43.
Item 46. 46 will not, I'm led by the
I'm being led by the learned additional advocate.
I'm paying for not to the, he's not available.
Not available. Who are you representing? Respondent number 4.
Yes.
Successful bidder. What about the tender? Is it over?
My lord, the work has been,
And the work commenced, and has it concluded?
No. There is urgency, there is some urgency here.
What is the urgency?
Because, based on a document, my lord, I was a successful bidder in the state tender process. Based on a false document, my lord, they have issued tender in favor of private respondent.
you were seeking adjournment or you were proceed to hearing? On the one hand, you were seeking adjournment.
I object the prayer of fixing the matter in the next circuit, my lord. Let it be fixed on Monday, my lord.
What remains?
My lord,
If in the merit of the matter, it says it has been submitted that the tender work has already been issued, the work has commenced. At this stage, will it help in keeping the writ petition pending?
Lord, kindly keep the matter on Monday for final hearing, my lord.
What is to be heard?
Lord,
Vacating application was filed, that was allowed. Did you challenge it in appeal? Then, when was the order vacated?
on the last circuit.
Last circuit means 15th of December. Then, still now nothing you have done. What is to be done now? What remains?
Actually, I am led by Mr. Odhikari, my lord, some time.
Somebody is leading is all right, but then in the facts of the case, what remains to be decided?
Madam, may I indicate one?
Work order was issued in July 2023. July, and the stay was 4th of August. Yes, please.
My lord, this is the project, housing project in the tea estate, my lord, for the workers. And with this regards, my lord, the work order has been already issued in the month of July, my lord. Thereafter, there was a stay order in view of that work could not be executed. And then by an order of the December of 15/12/2020, the agency has already executed in the verge of completion, my lord.
What is the time period for conclusion of the work?
My lord,
2.5 years.
that is the phase wise, my lord. Phase wise, my lord.
Phase wise. So it is continuing.
Yes, continue.
What about the opposition?
You have already filed. Opposition, you have given our opposition.
But
Reply
reply to,
Reply was filed.
but
Reply
reply you have
also
not,
filed.
I have not supplied a copy of the reply. Yes. I was there at the time of vacating and you said I am not there. What? So you are not ready and you are seeking,
Reply is there on record. Opposition is also there.
so supply a copy to that.
I shall supply within the course of.
Accommodation has been sought for on behalf of the learned advocate representing the petitioner. Stop. Learned advocate representing the respondent number 4 also seeks accommodation. When to list it? Monday, I have already fixed up a lot of matters. List on Wednesday, 31st.
Malad, then can it be Malad Thursday, Malad, Wednesday? There are others matters also fixed. I have to argue before the honorable division bench, Malad. So Thursday it will be.
In that case, next circuit. Absolutely impossible.
I am ready because Wednesday.
Pick up the matter on Thursday. Friday is the last date. It is not possible. Let it remain on Wednesday. If you have any difficulty, let us see. We can always accommodate.
Malad, Lordship. 46, 7.
My state juniors will provide you.
47.
This matter is শতাংশ percent is happening. শতাংশ percent is happening, but unfortunately, he's not happening much.
He's not available. Why is he not available? He can always join online.
Yes, then, but yes, strictly asked me to take your adjournment for this second.
Because seeing me, I think so. Seeing me, I think so.
Can you please do it in the next second?
In the next circuit, he will remain.
Yes, that you will be happy with, we are happy with, sir.
Then, opposition and reply over.
So they are going to direction to file a affidavit in the form of report. They have given the report, we have filed our exception.
Report and exception all over.
All are.
ওটাতে ওরা ইয়ে দেবে
Yes, report is here. Exception is also here.
Yes, always. No, no, it's not. Is there? I'm just ওটার reply.
Learned advocate representing the petitioner prays for posting the matter in the next circuit. Stop. On such prayer, list in the next circuit.
Item 48.
48.
Milord, I beg to appear for the petitioner. Milord, there's a direction on the state, Milord, to file their affidavits.
Yes. Copy.
Milord, may I?
In November, there was a direction for.
No, Lordship, actually that was affirmed, but due to my marriage, I couldn't able to join in the previous circuit, Lordship.
You could have served a copy.
No, Lordship.
You enjoy your married life, no difficulty, but
No,
that
Lordship,
does not
previously
mean
I
you
already
can
served a
serve.
copy to him, but there is some modification, that's why I'm giving him the fresh copy, Lordship. Previously, I already served him a
So,
copy.
Milord, may I have a look and Milord come back tomorrow or Milord?
Won't you file a reply?
Required, Milord, within 2 days, Milord, I'll prepare a reply. Milord, if it can be taken up on Monday. Subject to Milord's convenience. No, Milord, not next
Monday,
Monday.
there is lot of, I have fixed up
Tuesday.
so many matters.
Tuesday, Milord, Tuesday.
The last matter I posted on Wednesday.
No, it's a recruitment matter pending since long. That's why, Milord. Otherwise, I
Yes.
would have insisted. Milord, very short question, Milord, whether the rules can be changed after initiation of the recruitment process.
4th August, I can see, service is not complete.
So you will find your reply now.
দুদিনে বানিয়ে দেবো যদি ধরনের ছোট পজিশন।
If there is a small, then they reply.
Affidavit in opposition filed on behalf of the respondent numbers 2 and 3 is taken on record. Stop. Copy of the same handed over to the learned advocate representing the petitioner in court today. Stop. List on 31st.
31st.
Reply if any may be filed in the meantime.
Yes, grateful.
31st কি বার? 31st is Wednesday.
Huh?
Wednesday.
Yes, it's a Wednesday. In case you have a difficulty, please let the court know.
Malad, that's the reason I said, because all the appeals should be taken up on 31st and 1st by the honorable division.
Only you are assisted by other councils also.
In that case, it will go to the next circuit.
So let's see, Milord, let it be there on Wednesday, Milord.
Let it remain. In case you are held up, we will accommodate.
Item 49.
Because I'm appearing for the petitioner.
And somebody must be assisting you in this matter. Miss Bose was there.
She will be there, Malad.
Yes, please make her conversant with the facts. If required, then
Definitely.
the matter can be adjourned.
In the meantime, then advance copy please supply.
Yes, please serve.
Otherwise,
Yes, yes,
I will.
so that they can get ready in the
I
meeting.
will, I will.
you will supply me by Monday.
49,
Before Monday.
Because I'm appearing for the petitioner.
Because there's a tender matter.
Yes.
I am there for respondent number 1 and 2,
right?
the private respondents, my lord. Point of maintainability, my lord, has been kept open
Yes.
on 3 grounds.
What about
two.
the opposition?
Everything has completed.
I'm filing it, sorry. I'll file.
Oh, you have not filed.
Have you filed? It has been extended, my lord. I'm sorry.
Yes,
Milords,
the
I don't,
opposition appears to be voluminous than the writ petition.
Yes, my lord, documents are voluminous.
It became voluminous because two of the tender documents had to
Yes.
be annexed.
Otherwise, it's a small case, my lord. It's a very small issue.
Yes.
It was my reply. It's a copy, my lords.
Where is the original?
My lords, it's with my clerk, my lords.
With your clerk?
I'm extremely sorry, my lords.
I'll keep the
I've served them,
photocopy,
yes.
but then you get the original.
Yes, my lords. I've served them.
Yes, what is it?
My lord, first.
Reply to Nian. Yes, what is the
My
matter?
lords, in this writ petition, my lords, I am challenging the work order that has been handed over to private respondent number 4.
Who is appearing?
Private respondent.
Private respondent, my lords,
I'm appearing for the statement.
private did not appear, my lords. Did not appear,
Did not appear.
my lords, no.
But the private respondent number 4 will be the most affected party.
Yes, my lords, but they did not appear, my lords.
Can the matter be heard in the absence of the private respondent?
My lord, point of maintainability.
Are you taking up the issue of the private respondent
No, my
also?
lord. Point of maintainability has been raised by me.
My lords, may I submit, my lords?
All right.
My condition, my grievance was that the essential condition of the contract had been violated. The first condition of the contract.
Notice inviting tender
Yes, my
possibly.
lords. The first condition was that this was a contract for packaging of milk, my lords.
Before your lordship goes into the merit.
I'll just understand. I'll
As your
keep this in mind. Yes.
Packaging of milk, tender regarding packaging of milk, my lords. So in the first condition, my lords, there was a condition in the first condition in the tender document. There was a condition that the packager has to have a minimum 30,000 square feet of land having an adjacent road of 25 feet wide, my lords.
Where from are you getting that?
Page number 26 is the tender document, my lords, of my writ petition.
Yes.
Page number 26 and 27 is the terms and condition, first condition.
26.
27 is the terms and condition.
27.
First condition, my lords.
Yes. And this was in Murshidabad.
Yes, my lords. But the packaging plant was in Siliguri and the work is in Siliguri, my lords. So substantial cause of action lies here, my lords.
And anybody can apply.
Yes,
Is
my
it
lords.
restricted only to the
No,
district
my
of
lords, it's
Murshidabad
open to all.
area?
It's open to all. Yes, my lords. They what they do is usually they publish this on their website, my lords. These tender.
Yes.
So, my lords, in the reply to in the affidavit which has been filed by learned senior, my lords, they are taking a stand that this is not an essential condition. What they are saying is this was one of the many essential conditions. So they have very cleverly evaded this question, my lords.
But then a cause of action arose in Murshidabad.
My lords, but the packaging plant is in Siliguri, my lords.
The tender was issued from Murshidabad. All the agreements signed at Murshidabad. In fact, the petitioner is the existing tender holder in respect of the same work, my lord. They've been doing it for 3 years.
Yes.
And even then, my lord, their agreements and everything were signed at Murshidabad. So this is my point I have taken up in respect of the territorial jurisdiction. The second point, my lord, that I am not a state under Article 12 and I'm not amenable to state jurisdiction because, my lord, I am a cooperative society.
Yes.
Now,
Private cooperative society.
yes, my lord.
My lords, but kindly
Not funded,
No.
not under any type of supervision under the
my lord.
state.
I dispute this, my lords. Kindly
I'll
take the
tell you.
affidavit.
Wait.
No. It is, my lord, what happened that under the Operation Flood, the state supervises, but we are all independent. For every district, for 9 districts, my lord, there are this 9 cooperative. Now we, my lord, act more or less as AMUL acts, my lord. Our members are the farmers and the cattle owners. They come and give us the milk, we procure from them. Either we ourselves, my lord, process it and make other products, or, my lord, we engage others. As in the case, my lord, petitioner was doing it for 3 years, and now, my lord, the tender was put. It's a self-financed, independent. A similar question, my lord, had arisen before this honorable court. My lord, this is a reported judgment reported in 1996, volume 100.
In respect of Bhagirathi?
In respect of another cooperative society, my lord, under in the similar structure.
All
That
right.
was in respect, this is in respect of Murshidabad, this is in respect of Malda. My lord, this is reported in 1996, 100 CWN 657. তোমার কপিটা আছে?
Page number 657.
Yes, my lord, I have.
Please give. Let me see once.
The coordinate bench judgment order passed by Honorable Mr. SB Sinha, his lordship was there. My lord, this question had come up before, this same question. Now, if your lordship, my lord, I'll take a copy to দেখো তো না আছে তোর একটা কপি ঠিক আছে আপনি করুন না আমি জাস্ট paragraph 17 my lordship 16 my lord kindly gives me one moment my lord. I'm just getting used to this soft copies now. My lord, paragraph 16 my lord is there.
Yes.
Yes. The primary question which arises for consideration in this application is as to whether the writ petition is maintainable. The question is to whether a cooperative society is a state within the meaning of Article 12 of the Constitution of India. Is a vexed question. It is now well settled. But then the discussion
Reasoning.
now kindly comes to paragraph 38.
Yes.
My lord is there, yes. In the instant case, it is not disputed that the respondent union was not earlier a department of state. The state merely made out a project so as to enable the farmers to form cooperative societies at the village level so that they can sell their products to the respondent number 5 milk union. The fund for running such cooperative societies had to be raised by the members themselves who were their shareholders. The state and/or NDDB merely extended their help, guidance, and finance so as to enable the society to tide over their financial difficulties. The respondents in their affidavits in opposition have clearly stated that some members have been nominated in the board with a view to realize the loan advanced by the state and the NDDB. In view of my findings aforementioned that the respondent number 5 milk union is not a state within the meaning of Article 12 of the Constitution of India, no really can be granted to the petitioner in this writ petition. This is it. And if your lordship kindly takes up paragraph 1 and 2, here my lord, a little background is given, it will be clear, my lord.
Yes.
Yes, the petitioners are employees of Boer Cooperative Milk Producers Union Limited, the respondent number 5 herein, which is a cooperative society registered under the West Bengal Cooperative Society Act. The state petitioners filed the writ application inter alia for issuance or whatever, my lord, for that relief. So this was, my lord, one of the milk unions for the state district of Malda. Now I am, my lord, for established. I have for the district of Murshidabad. This is the only difference between this and that. And the fact of, my lord, there was a dispute between the employee and the employer, and here, my lord, between a tenderer and the tenderee. But, my lord, the question of jurisdiction and
maintainability
yes,
of
my lord.
Article
So
12.
that, in my respectful submission, my lord, this has been settled by a honorable coordinate bench.
Yes, please.
My lords, I am also relying on a Supreme Court judgment, Ajay Hasia, my lords, constitutional bench judgment.
Yes.
4 paragraphs I am relying on.
Citation. No, here, hold on.
1991, 1 SCC 722. 1991, 1 SCC 722. My lords, 4 paragraphs I am relying upon. And my lords, I'll take you through their affidavit in opposition. Page number 6 of their affidavit in opposition, my lords. Paragraph number 6.
Yes. No, from the judgment, you please show me the paragraphs.
My lords, para stated in the first.
9, 11, 12, and 15.
Yes, my lords.
Yes, what does it say?
My lords, kindly see paragraph number 9. They are relying on that international airport. Dayaram Shetty case, my lords.
Does Bhagirathi fulfill these tests?
Yes, my lords.
Show me.
My lords, I'll take you through their affidavit, my lords. Page number 6 of their reply, their affidavit, my lords.
Page number 6.
Yes, my lords.
Which portion?
My lords, fifth line onwards, it is denied that the respondent number 3, being the DM and collector of Murshidabad, is directly involved in the decision-making process of respondent number 1. I say that the respondent number 3 has been appointed as a special officer for the purpose of holding elections of the board of directors of respondent number 1. They are admitting this, my lords. I say that the respondent number 2 was never part of A. The state merely made out a project so as to enable the farmers to form cooperative societies at the village level so that they can sell their products. The fund for running the respondent has been raised by the members themselves who are their shareholders. The state merely extend their help, guidance of implementation of various projects and finance so as to enable the society to tide over their financial difficulties, my lords. So, my lords, in this case, a project worth a tender worth rupees 5 crore rupees, where the funds of several farmers are involved, my lords, have been arbitrarily handed over to a private respondent number 1, who don't even specify the first condition, my lords. Kindly see their paragraph number 9, my lords. Next page, page number 7, paragraph 9. From the middle, my lords, I say that it was one of the many conditions of the said EOI that the packaging station has to be set up on a land not less than 30,000 square feet and having an adjacent road of minimum 25 square feet wide. I say that this is not the only technical condition for the fulfillment of which have made a participating bidder technically eligible. I say that respondent number 4 was found to have fulfilled the other technical conditions of the said tender and importantly the financial quotation. Without even clearing the technical bid, my lords, they have given him go for the financial bid, my lords.
What is the state stand?
State has nothing to say.
My lords, I'm
What do you
also,
mean to say? State has nothing to say.
my lords, I'm also relying on one more.
1 and 2, they are the one who wrote the tender.
Everything said and done,
And they are
whether, what is the role of the DM?
My lords, kindly take page number 57 of my writ petition. Kindly for a moment.
Role of the DM?
But first, the respondent number 1 and 2, they are the answering party first. Why they
The court has
50.
come up with a specific query from you. What is the role of the DM?
DM role in this matter, particularly the allegation is that the tender.
Listen, what the allegation is, the petitioner has already mentioned. 1 and 2 has also made submissions. I want to know what is the role of the DM.
No representation has been made to DM.
Forget representation. What is the role of the DM in the matter of this Bhagirathi? What role does the DM play?
DM has no role play to issue tender or to pass any.
Tender is issued by Bhagirathi, it is all said and done.
Bhagirathi.
What type of supervision does the DM have over this? You do not know. You need to take instruction.
My lords,
yes.
Kindly take page number 58 of my writ petition, my lords, for a moment. This was the previous contract which was tender which was issued to them. And my lords, kindly see the representation by me was made to the DM, my lords. Because all the negotiation is done by the DM office, my lords. In fact, my lords, I am told that all the note sheets also, all their order sheets also contain their signature, my lords.
Signature of the DM?
Yes, my lords. DM as well as ADM, my lords. That is what I have been instructed, my lords.
Supervisory role, my lord.
And my lords, kindly,
even in the, even
some type of supervision possibly the DM has.
Yes, my lord. It is also the in the judgment which I had relied, my lord.
Yes.
There also it is stated that the supervisory function of the state is there.
To what extent? Let us
Because
see.
I am, my lord, been asked to implement a project which is actually a project of the central government, my lord, project plan, under the project plan. So that way it flows down. And the judgment which my learned friend has just relied on, my lord, that is parallelly, my lord, reported in All India Reporter 1981 Supreme Court 487. That has been discussed in the judgment I have relied on. Paragraph 13, 21 and 34.
My lords, my submission is that there is a deep and pervasive control.
And moreover, my lord,
H.
Moreover, my lord, even let us, my lord, for the sake of argument, my lord, take it that the writ petition is being held to be
Maintainable.
non-maintainable. I am, my lord, now saying that if it is held, I am not saying that it will be held. They will not be without remedy, my lord, because the tender document contains an arbitration clause. Kindly seize, my lord. It is at page 32 of the writ petition. In case of any dispute or difference shall at any time arise between the two parties, that is Bhagirath and packaging station, in respect of the concerning anything herein contained or arising out of above arrangements as to the rights, liability and duties of the said parties hereunder, or as to recover of any amount, the same shall be referred to the sole arbitration of chairman special officer of the Bhagirathi Murshidabad, such and such, madam.
May I reply, my lords?
Is this the DM? Chairman Special Officer is
No,
not the
no,
DM.
no, my lords.
This is your
Yes.
officer.
My
All right.
My lords, may I submit one thing for that arbitration clause, my lords?
Yes.
My lords, this is for the person who has been selected, the party of the, I'm not a party of this
I have
contract.
followed that. I understand.
And my lords, I'm also relying on one more judgment, my lords, of the Supreme Court, 2020 17 SCC 577.
2020
17 SCC 577.
ये नाम को petitioner है सब?
Veerbhadra Irrigation Development. Three paragraphs, my lords, I have stated in the top.
Yes. This is government contract.
Yes, my lords, but on the
Essential
principle of essential condition of the contract, my lords. It cannot be violated, my lords.
But then
in my respect,
you have to overcome this
Yes, madam.
first.
Grateful.
And then only you can come in over here. Otherwise, till you can overcome the barrier of this maintainability, you will not be, you will not get the benefit of this judgment. Very well. Let us see what is to be done. You please come. The petitioner is aggrieved by the act of Bhagirathi Cooperative Milk Producers Union Limited in issuing the tender in favor of the respondent number 4. Stop paragraph. A preliminary objection with regard to the maintainability of the writ petition has been raised by the respondent numbers 1 and 2. Stop next. The parties have advanced argument with regard to the issue of maintainability. Stop next. None represents the respondent number 4. Stop next. Let a further notice be issued upon the respondent number 4, intimating that the matter will appear in the list on 1st February 2024. Stop. The learned advocate representing the district magistrate and collector shall take specific instruction with regard to the role of the district magistrate in the functioning of the respondent numbers 1 and 2. The list on first. Affidavit in opposition and the reply filed thereto. Affidavit in opposition by the respondent numbers 1 and 2 and the reply filed thereto by the petitioner be retained with the records.
Grateful.
Act तारीख रख लेंगे लास्ट act तारीख रख लेंगे
Act तारीख. Oh, ठीक है
चलो 32